9:01, all are in attendance. And then I want to turn it over to Jim Adderholt to lead the pledge and the invocation. To the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Please remain standing.
Dear Heavenly Father, we lift up the men and women who are working on Estero Boulevard this morning. We pray for their safety and their protection. We lift up those in the audience. We lift up the staff for the town of Fort Myers Beach. We lift up the members of the LPA. We ask for wisdom, discernment, and pray that all that we do and say today does nothing but bring honor and glory to you. Amen.
Amen. Thank you, Jim. All right, next on our agenda is the approval of the minutes from the last month's meeting from November 12th, the full meeting, and then the November 19th session for the variance. Any questions, concerns, changes on the November 12th meeting minutes from the full meeting?
Motion to approve, and it says read.
Hang on one second. Any changes on the on the next meetings of November 19th meeting minutes? Any changes, concerns, misspellings? No? Okay, go for your motion.
Motion to approve both minutes.
I second it. All in favor, say aye.
Aye.
Aye. Jason?
I don't know.
We're about to open a public meeting,
Sure.
and we need swearing in.
I don't believe for the first one we do, but I can, if you want to hold. I don't know where John is. Yeah. If you want to go over the first one.
But don't the witnesses need to be sworn in? Yeah. Well, but they're going to be first up.
There he is.
There he is.
Speaking of the devil.
We were swearing you.
Swear.
All right.
Not really. Wanting you to swear them.
So why don't I just introduce it, and then when John says
Okay,
something, we can do all that.
Town introduces the motion. So we're going to open the public hearing for the review of the non-conforming use determination for 1661 Estero Boulevard.
All those that want to testify here this morning, can you please stand, raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth. To the extent that you need to disclose any ex parte communications, now would be the time.
Any ex parte communications? Dan Hughes? Tim?
I've driven by.
Scott?
I own a business across the street.
Jim?
Site visit.
Dan?
Drive-by.
Site visit.
Site visit. Okay, all ex parte communications been disclosed? Are you going to read the?
Sure. So the for 1661 Estero Boulevard, the property owner has submitted a request. Well, we had conversations about determining that it was a legal non-conforming use, and that the use has been the use being commercial parking, or as our code generally refers to it as permanent shared parking, continuously on the property for a number of years. There was some documentation submitted that we reviewed and don't believe it meets the test of providing that information. However, we afforded them the opportunity to come before you and then before the council to review the history. Perhaps there's other history that we're not made aware of. But basically you have the packet in front of you, and they'll make a presentation today of why they believe that the use should be recognized. Without findings of it being a continuous illegal non-conforming use, essentially they need to go through the process to get approval for the permanent shared parking per the Land Development Code and meet the requirements outlined in the code. And that's staff's opinion on that right now, is that they do need to go through that process. However, we'll let them make their presentation. And
Anyone here from the applicant?
Yes, thank you very much.
State your name for the record, please. And we all should have the presentation too as well.
Yes, thanks very much. My name is Steve Hartzell. I'm an attorney with Pavis Law Firm. I'm here today on behalf of Carmen Nacarado, the owner of the Kia Estero shops. Mr. Nacarado is with me as well today. Public speaking is not one of his fortes or favorite things, and some of you may be able to appreciate that. So he's asked me to speak on his behalf, and I may at some point ask him just a few questions to help him along, if that works with you folks as well. Our request, as Jason has pointed out, is for the determination of an existing non-conforming use for commercial parking to allow daily paid parking to continue at the Chiastero shops. This is the location of the subject property. You all have been there, so I'm sure you're familiar with that. The Chiastero shops are located at 1661 Estero Boulevard. They are in the downtown district. According to Land Development Code Section 34-671, the purpose of the downtown district is to create the desired quality and character for the center of pedestrian-oriented commercial activities. That's a pedestrian-oriented district. Preference is given to pedestrian movement. Visitors are encouraged to park once and walk around the businesses on Estero Boulevard and visit the beach. The whole context of the downtown district encourages the provision of more parking spaces to facilitate pedestrian activity in the district. Parking space reductions are provided for. Individual property owners control their own rights of using the parking lots. It's encouraged to allow wider use of parking spaces for a fee in some areas, like along Old San Carlos Boulevard. This is further underscored by Section 34-2019, other use of parking lots. Parking spaces that are not in daily use and are located in parking lots having 10 or more parking spaces and meeting the other requirements of the division may be rented to the general public during peak periods. The Chiastero shop's parking lot has more than 10 spaces and fits the requirements of 34-2019A, even if it weren't already an existing non-conforming use from the Lee County zoning. It also fits into the intent of the downtown district to provide as much flexibility as possible in favor of providing parking spaces for visitors to the beach. The problem that you all are, I'm sure, as aware of as anyone, is that the demand for parking spaces in this area of Fort Myers Beach is huge, but the supply of parking spaces is woefully inadequate, insufficient. The imbalance with huge demand and insufficient supply creates conflicts and problems for businesses like Chiastero shops that have large parking lots. So far, the lack of parking has not prevented people from coming to the beach. And they have the expectation, particularly in the downtown district, of being able to park and shop or eat or go to the beach. When they arrive, if they can't find adequate parking, they'll park illegally in areas where you don't want them parking on the beach, or they park in parking lots where businesses need that parking for their customers. Consequently, owners of buildings with parking lots that are near the downtown district or accessible to the beachfront have to pay employees to monitor the use of their parking lots. Those added expenses of paying for parking lot attendants have to be offset, and revenue from paid parking helps to offset that monitoring cost. Frankly, it's always been that way. Which brings us to the Chiastero shops, non-conforming use for the paid parking. You'll see on slide 9, and it's a little difficult to see, but this is a tax card from the property appraiser's office for the 1661 Estero Boulevard. The purpose basically is to show that this parking or this shopping center was constructed in 1976. When we look at aerial photographs, you'll see on the left-hand side is the 1974 Lee County zoning aerial. It's a segment of that for this part of the beach. And then on the right-hand side, you'll see the 1977 aerial that demonstrates that in 1977, the Estero Shops was completed. It was started in 1976, at least finished by 1977. That's the most recent aerial after the 1974 aerial. The aerial on the left is helpful to understand, and it's difficult to see, and I apologize for that. But in the very middle of that, this isn't really working, in the middle of the aerial on the left, you'll see the handwritten note that says BU1, which represents the Business 1 zoning district. It's interesting, I think, historically, when you look at this 1974 zoning aerial and compare that to the digital aerials and digital zoning materials that you have today. Back in the 70s, when the county first had its zoning, this is the way they took care of things. They were using pen and ink on aerial photographs that they kept in the county offices. But this showed that the BU1 zoning district was what the zoning was in 1974. I've also included in slide 11, and it's difficult to see, but it's an excerpt from the first Lee County zoning regulations. They were adopted in 1962, and they were still in effect, those zoning regulations were in effect in 1976 when this building was constructed. That was Resolution Z-1. And I included just an excerpt of Resolution Z-1 in your packets, and it comes up on page 25. It shows that the regulations that were in effect for the BU1 Neighborhood Retail Business District contains uses that are permitted in the BU1 district. And the middle of that very long list, and I apologize, it's hard to see, but I did highlight it so you could see it. It shows parking lots, commercial. Those are lots that allowed for paid parking back in 1976. And I appreciate that, given the kind of quality of the materials, the staff in the yellow sheet acknowledged that that was a permissible use back in 1976. Back then, zoning wasn't nearly as sophisticated as it is now. During the early years of the county, I mentioned the handwritten notes on the zoning aerial. The demand for parking was there back in the 70s, and people were going to park there anyway. So if you had a commercial parking lot that was a permissible use, you charged parking to cover the costs of your parking lot attendant, and that was just a common practice. The attendants made sure that the tenants had enough parking for customers, and extra spaces were then used for the daily paid parking. That activity was permissible under the zoning at the time. It's continued for the past 40 years as a non-conforming use. Created a win-win situation for visitors and for the town, so that parking spaces that were available were actually being used as efficiently as possible. Since that time and before the town incorporated, while it was under the Lee County zoning, extra parking spaces were used for daily paid parking, and that was permissible under the county. Even after the town incorporated, that daily paid parking has continued at Kia Estero shops without interruption, effectively. It's never been abandoned. The Kia Estero shops' daily paid parking ought to be recognized as a non-conforming use. I've included in slide 12 an affidavit which is further evidence of how long this has been going on. You can imagine going back and trying to prove what was going on 40 years ago is challenging. Mr. Nacarado is familiar with Yvonne Lucas. Yvonne was an officer in the corporation that owned the Kia Estero shops when it was purchased in 1980. She explains in this affidavit, sworn affidavit under oath, that the parking lot was used for daily paid parking before they purchased it in 1980, and that it continued during the time that they owned it. She had personal knowledge of those continuous activities prior to the purchase of the property, and for the 21 years during which her corporation owned it and managed that parking. Now, Mr. Nacarado is presently the manager of the Chiastero shops. He's the owner of that property. He's here today. He's very familiar with the property. He was a longtime visitor back in the early 2000, at the kind of the turn of the new century here, and was aware of the property and became interested in purchasing it. Kind of to speed things up, there are about 4 or 5 points that I wanted Mr. Nacarado to confirm for you, and if you have questions, he'll be happy to answer them to the best of his knowledge. But if I could, Mr. Nacarado, would you come to the microphone for him, please? During the time from early 2000,
To be specific, it was 2001 when I came, the first time that I came over here in Lee County. So I bought my first duplex on Madison, 154 Madison, through Giovanna there, Luca, Tropical Hot, okay? And I became a friend.
excuse me
with
for
her.
just 1 moment, just to keep the record straight. Would you tell the LPA what your name is and where you,
Carmelo Nacarado.
and where do you live?
I live at, oh, geez, 15, what is it? Oh, boy, I got a couple.
Just the street.
My residence, it's in Michigan,
Oh.
okay?
And do you own the property at the Chiastero shops?
We do.
At
Yes, sir.
1661 Estero Boulevard? Okay.
And like I said, I got to know Jovan. I became a friend. I fell in love with the building in 2001. I says, Jovan, I know you own 10% of this building, but because of the location, because, sit on 2.5 acres, she told me all the history. She said it's owned by some rich, German lady. I said, whenever she decide to sell it, just to let me know. I said, it's sold in 2001. And like I said, then I bought more property. I bought a few more properties on the beach over here. I own property all over the Lee counties. Okay, and I still work like a fool. Okay, so they were doing beach parking in 2001. When I first putting my foot on the property, now all of a sudden, after
I'm sorry, I want to interrupt you here before we get up to that point. So during that time from 2001, before that and after that, were you aware that parking spaces were being rented out on a daily basis?
Absolutely. Before, yeah, absolutely.
Okay, were there attendants there that provided parking lot security and rented the extra parking spaces?
Yes, sir.
Okay. When you purchased the property at that time, did you buy it relying upon the revenue
Over
from
the
parking?
lot, because as far as, renting the upstairs, the buildings upstairs, there is no market. Them buildings, I don't know what I gotta do. Either I might have to come to you guys to change the zoning upstairs, to turn them into a condominium or apartments, because like I said, there is no demand.
Right now, are there only 5 of the 20 units at the Chiastero shops being leased?
Well, what?
There are only 5 of
4.
the units? 4 of the units are being leased.
1, 2, 4 of them.
Okay. So is it correct to say that there's an abundance of extra parking spaces at Chiastero shops?
Absolutely.
Okay. Do you presently still have a parking lot attendant that's required to
sir.
keep it from being filled up? What happens
As
if
a matter of fact, in 2017, after I bought the property, I submitted for a permit. I got my permit to close the entrance, the entrance right next to the hardware store there, because we couldn't, 3 people, we were 4 people there, we couldn't control the people pulling into the parking lot. I said, I got a bigger problem over here. So I came over here, I submitted, I explained it to the previous administration there. I said, listen, we got a bigger problem over here. Someone is going to kill there because behind the building, we cannot control the parking lot.
So that was to control your parking business? Am I correct on that?
Parking lot,
Because
yes,
that was
sir.
to control
Yes,
the
ma'am.
parking business of your business, you had to close that in. Am I correct on this?
Yes.
Okay.
So what, they issued me a permit and everything. It was fine and dandy. All of a sudden, I mean, you know, when I was out of the blue after 2.
But that was to be able to control the egress of people parking in your parking lot and the ability to charge them for parking, correct?
Right, and now they have to come in, you know, either, right there, you know what I'm saying, right across from the entrance by the sign or in the back. So now it's manageable.
For turning your parking lot into your primary business.
Was it also for safety purposes?
Safety
that
purposes, absolutely.
that second
Right,
access
right,
was
right,
cut off?
right.
Did the town do that, or it's a county road?
No, he did it.
I closed
You did.
it, I closed it.
And you
I
got a permit?
Because the
over
apron's
here.
still there.
They issued
From
me
whom did you get a
and
permit?
everything. Pardon?
From whom did you get a permit to do that?
The town,
Town,
Town of Fort
to
Myers
close
Beach.
that off.
Is that true?
the previous administration.
You're talking about I'm sorry, Jason Green, Community Development, you're talking about the
Now the second-
Estero side? No, there wouldn't have been to close that driveway, and I don't think they've closed the driveway. The sidewalk matched when they
They
closed it on the land side and put
Yeah.
landscaping in.
But the
They
apron's
didn't
still
close the actual driveway. The actual driveway is still physically there. When they put in did the improvements on Estero, it's still the dip for the actual driveway. So on his property side, yes, and there wouldn't have been a permit for landscaping.
What is that road we're talking about, was that ever, is that a dedicated road?
I thought we were talking about the frontage on Estero, where he
We were
closed.
talking frontage. That
Oh, you're
little-
talking on the
That
front?
little
So the-
spot right next to the hardware store, that's the
Yes,
apron
that
there.
where they
that
closed
he
it
closed it
off.
off so that he could control more parking. He could control
Yes,
the ingress.
But I'm talking about from right angles from the Estero to that, the road that used to be the exit.
Right.
That's just private property,
Correct.
okay?
So there is a public road there that leads to the back, I think the post office, whatever's back
Right.
there. And so I don't know of any permits to close a driveway, and the one on Estero is technically still there. They've just done landscaping to block off that entry and exit. And I would assume that there's probably been parking spaces added in that place that used to be the drive aisle. So we haven't
Okay.
investigated that yet.
I just wanted that clarified. Keep going. Sorry.
Well, now I don't know
That's-
I forgot. Sorry, I'm an old
That's-
man.
No, that's okay. Thank you very much.
What-
Do you
what-
have
what-
any additional questions for Mr. Nacarado?
Questions for the applicant? I'm going to start down here with Jim.
I just had a question with respect to, you say only 4 of the shops of the 20 options are occupied at this point?
Yes, sir.
There are only 4 tenants left.
And is that, you say that's because of a lack of demand? Is that what you're saying?
Yeah, right, there is no
you-
demand. I mean, the people,
He
that-
wrapped it up at that.
I got calls all the time, you know what I'm saying? I got a couple, Subway used to be there. I had a couple of calls all this time. I mean, you know what I'm saying? Ever since they moved out, and they only want to pay me $1,000 a month. How can I listen to a special for $1,000 a month?
Talking to the microphone.
Hey, I apologize. I thought you were done with your presentation when you said you were done.
No,
So-
I just wanted Mr.
Okay.
Nacarado to
So-
be able to sit down.
All right.
Hey.
Let's let him sit down, then we'll ask questions. He's not done with this presentation. I thought he was when he said he was
That's
done.
fine, sorry, I'm pretty close to wrapping up. Go ahead and
Okay.
sit down. No, you're good. Thank you.
I apologize. I thought when
No,
you
no,
said
no, I understand. It was my fault. On this slide, which you're looking at on slide 13, is the site plan that was prepared in 2017. It shows the Kia Estero shops building in the first floor units. What we've done is to blow that up so it's a little bit easier, just to demonstrate that there are 135 parking spaces associated with the Kia Estero shops. When we're looking at the Land Development Code, we would submit that this is a non-conforming use under the Land Development Code. For 40 years, visitors have been using that parking lot for beach parking and other daily extended parking, and making effectively a parking lot attendant at that location a necessity. As I mentioned, the cost is offset by requiring daily visitors to pay for that extended parking if they're not customers of the center. For over 40 years, the process has been going on as a matter of necessity, and we would submit that it's consistent with the past and present goals of Fort Myers Beach. It supports the Park Once philosophy. As Mr. Nacarado pointed out, that non-conforming use is now being re-examined and challenged. That's why there's a code enforcement matter that's been filed for that, because it doesn't meet the present standards for the city's shared parking lot definition. But if you look at the definition of nonconforming use, which is on the slide, Section 34-3202 provides the definition. A nonconforming use. For purposes of this article, the term nonconforming use means a use or activity that was lawful prior to the adoption of any ordinance from which this code is derived, but which fails by reason of the adoption to conform to the use requirements where the property is located. And then Section 34-3203, illegal buildings, uses, and lots, basically underscores that. If a building or a use was not lawful when it's created, it shall not be considered a nonconforming use. We would submit that from the history and from the evidence that's in the record, in the BU1 zoning district, commercial parking lot was a lawful use when the Kia Stero shops were created. It's been going on for decades, this daily paid parking out there, before the town was incorporated, and it's continued afterwards. And it deserves the protection that the Land Development Code provides for nonconforming uses. It meets the requirements for nonconforming use. It's consistent with the purpose and intent of the downtown district. As Mr. Nacarado testified, only 4 out of 20 units are occupied. So there's abundant parking available. Over 75% of the space is...
28 units total.
Over 75% of the space is empty. Revenue from that paid parking is required to keep the shopping center alive. It pays for insurance, maintenance, the various costs, the landscaping that's associated with it. Okay. If the nonconforming use continues, parking remains available for both customers and visitors, and it's monitored by an attendant. As Mr. Nacarado was explaining, and he can answer questions, but the revenue from this paid parking is the reason that he purchased it. And frankly, it gives him the ability to continue to operate those shops, which aren't, you know, terribly successful on their own as retail businesses. It helps him to pay for all of those costs. If that nonconforming use is not allowed to continue, there won't be an attendant. The parking will continue to be there. It'll just be used free by the same visitors, whether they're customers or not. That shopping center isn't going to continue. It'll fail. And if it does, it becomes simply a vacant eyesore that still gets used for parking. It just is no longer maintained or monitored. We submit that the evidence shows that that daily paid parking was not only a permissible use under the county's code, as explained in the nonconforming use definition, but it's been lawfully existing since the time that the county regulations were in effect. Before the Fort Myers Beach regulations were adopted, we're requesting that you, as the LPA, make a recommendation to the town council to find that this is a lawful non-conforming use that ought to be allowed to continue. We'll be happy to answer any questions. Thanks very much.
I'm down here.
Just to follow up on that, you said there's 4 of 20 currently occupied. If all 20, or I don't know, did you say 28? If all 20, if all 28 were occupied, would this become a moot point? In other words, would those businesses need those parking spaces?
Probably, yes.
And what you're testifying to today is that when your client bought the property, this was the business model, that to have a majority of the businesses be vacant and then to make it a profit center based upon parking. That was the business model?
I don't know that that was the business model. That was the existing use. It was the way that it was being done. It was the only way, frankly, that they could afford to pay for that. Again, even if you understand, even if all of those units were occupied, it still requires a parking lot attendant. I mean, just from the sort of the practical standpoint, if nobody is there to monitor the parking, what happens is people who are going to the beach pull up and walk across the street. They take those parking spaces all day long. If there's not somebody there to essentially say, no, you can't park here, we're going to have you towed. Or we have extra parking spaces, you can use these parking spaces, but the other parking spaces have to be left for customers or of tenants of the building. So it's going to be necessary to have a parking lot attendant. There just isn't any way really to get around it. And I mean, you see that up and down Estero Boulevard.
I appreciate the fact that you believe you're in compliance today. Could you just comment for our benefit what the town is suggesting for you to become in compliance? Could you discuss the potential cost and hardship of that and why that's not an option as you make your arguments today?
Certainly. Part of what the town is asking Mr. Nacarado to do is to apply for a variance or for permission. And frankly, because it's an existing non-conforming use, there shouldn't be a need to apply for that. That's the reason that the non-conforming use provisions are in effect. It says you're allowed to continue what was lawful back when the county regulations were in effect. You can continue doing that. Frankly, part of the problem that Mr. Nacarado has is that if he applies for that and he's denied, what's he to do? At that point in time, he's largely waived the right to argue that he's got a non-conforming use. That's the reason that we're here today, is to show that this has been going on since the place was built.
And I appreciate that, but Mike, just real quick, in the notes that we have from the town, it says landscape buffers are an example of items that can't meet the current town LDC. Can you comment, in order to meet those qualifications, can you discuss what sort of landscape buffers would be required of your client?
Honestly, I was under the impression that the landscaping that Mr. Nacarado had done since he purchased the property was actually an improvement over what was existing there.
No, excuse me, sir. Excuse me. You cannot make comment unless you are at the microphone and use your name. So don't make comment from the field.
Yeah.
So if
Sorry,
you'd like,
we're just
you
not
can come
used
up
to
and
this.
speak, but you cannot say it from the audience. Are you following me?
So, okay, this is Carmen Nacarado. How much did you spend on the landscaping?
I spent over $35,000 landscape. I planted 64 palms.
Why are those boards still on where your egress used to be? Why are those boards still looking like a fence? I don't understand that.
Oh, the boards are right there. If I don't have those boards right there, I gotta put some kind of, barrier. I gotta have some barrier there. I don't know the people are gonna go through, walk right through the shrubs there.
So you have an
So
illegal
I'm
fence?
waiting to, you know what I'm saying? I gotta give it a little more time, so they close in, and then, we trim them, and I hope, and then I'm gonna walk
So
right through.
you're admitting that you have an illegal fence there?
That two of words.
Let me have you sit for a minute.
Braces, they were there when I planted the palms, so they're still there.
Getting to your question, what are the challenges? This is part of the challenge. We've got a lawful non-conforming use that's there. The regulations have changed. I don't know what all of the additional landscaping requirements might be involved, but that's exactly the problem that Mr. Nacarado has when he talks to the town about what needs to be done. Maybe there's additional landscaping that also has to be put into place. We don't know what all of those changes are, or in order to bring this up to code. But that's the whole purpose of a non-conforming use, which is grandfathering. You had something that was lawful when you started it. It's continued. He's simply asking to continue to be allowed to continue to do that.
I'm going to go right down the line.
I'll yield to my colleagues. Thank
Dan,
you.
do you have anything?
Yeah, I had
coming.
similar questions to what Jim was asking. When your client purchased the property, I assume he knew it was non-conforming at the time he purchased it?
Yes, his understanding is that it was a lawful, non-conforming use.
What year
that
was
would-
that?
That would have been 2017 that you purchased it. That it was a lawful, non-conforming use, which basically means you can continue doing. He saw what they'd been doing. He talked to Yvonne Lucas, who said, yes, since, we bought it 2001, and before then, it was always used,
So he
always had
purchased it from Yvonne?
paid parking. I'm sorry?
He purchased it from Yvonne?
Yes,
Okay.
From the corporation that
From,
you represent?
from the corporation, yes.
On average, the parking, you say you need that to be viable, to keep it a viable structure. On average, you don't have to give me an exact number, how much on the best day or month would that parking spaces bring in if you were allowed to park as many cars there as you could?
I'm not sure.
In the summertime, it costs me money.
Okay, but I'm just asking the most you think you can make at one time.
Yesterday, he parked 6 cars, but if he wasn't there, the parking lot would have been full.
I understand that point. My question is, if every parking spot was full, how much revenue would that generate in 1 month?
All depends on what, how much you charge. If it's $5, you know what I'm saying? You talk,
Ballpark.
yeah, ballpark, yeah, I mean, you could bring in $1,000 a day in season, you know what I'm saying?
So we'll just say 30,000 in a month. If it was packed all the time,
No, like I
wouldn't
said,
do.
just in season, yeah, right. Season, yeah, January, February, March, that's, you're right.
okay, so if you were to average it out over the 12 months, say 4,000, if you were to average it, the total revenue you could generate?
Probably speculative. I mean.
Right,
you
I'm
can-
just-
you can
just
kinda
roughly.
tell that he's-
I'm just trying to put the math together.
9,000,
And,
8 or 9.
and where my question is going is, well, it's kind of a two thing. One, someone refresh my memory on how many parking spaces are required per business. If every one of those 28 places were an actual business, how many parking spaces would be required?
Well, so, I mean, I'd rather get into that when we come back to us, if you
Okay,
don't mind.
that's-
Just-
okay,
so
that's fine.
The answer is it's based on square footage and use. So certain uses have 3 per thousand, some have 5 per thousand. Restaurant has a different calculation. And so that all depends on square footage, plus in the downtown district, there's a discount, there's some math that involves, so.
Okay, okay.
They will present after.
That's fine. It kind of all goes together and kind of where I'm going with it. But, so of the 28 places, you had mentioned, some people have said they would do it for $1,000 a month to rent the space? No, I understand, but.
Okay,
if-
Mr. Carmine, you need to speak into the microphone,
Yeah,
please.
okay, I'm sorry,
Thank you.
okay. Hey, everybody knows Mr. Schenko, okay? He had a insurance, a title company, partnered up, for a year. Okay, now the title company, they were never there. They just to put a phone number on that sign there, you know what I'm saying? Because he stopped doing, real estate closing. I mean, his health, whatever it is. So he brought him in. So he's pulling out of there. Mr. Schenck said, Carmen, I cannot pay what we're paying right now. I said, what do you want to pay? He said, less than $1,000 a month. I said, Bill, you would have paid $1,500 when I bought the property. I says, you can stay over here. I says, but I cannot do it for $800 or $900 a month. That's the situation we're in. He's gone. He
So
moved out.
You moved him
I'm
out, you moved
here.
him out of 1,000 and keep the 800, so
Pardon?
you let him move out over, he wanted to pay less than $1,000, you wanted
He was
1,500?
paying with this other guy that came on board because, he stopped doing real estate closing. That was his revenue.
The economies say, keep
He
him,
couldn't do it anymore because you know what I mean. He's got a health problem. I know Bill for 18 years. He's a friend of mine. He said I cannot do it if I only can pay $800 or $900 a month. I said,
Okay.
the best I can do is $1,500.
Yeah,
And he moved off the island. I mean, it breaks my heart.
I understand. The reason I'm asking is.
Yes, sir.
It appears to me that the main argument is revenue, that it's not going to be a viable place without the revenue. So I'm trying to get my head wrapped around how parking at an average of $4,000 a month will bring you more revenue than having 28 full places that pay $1,000 a month.
Sure. There is no demand
There is,
for office space.
Oh,
Not
demand,
even
not demand.
retail.
This
Retail,
is just
everybody
questions for
shops-
my own
Sir,
thought
everybody
process.
shops online anymore. Retail, and that's, if you see what's going on out of the shop center in Picaro, okay? There are a bunch of retail centers there that are in the market. There are about 4 or 5 of them in the market because, like I said, everybody shops at,
Sure, you got to be
A point of
competitive.
order.
yeah.
I fail to see the relevance of this economic discussion here. I really do.
Well, I think
I'd like to ask the the issue here is whether we, as I understand it, whether we.
Well, he's making the argument for the non-conforming
Make a
business being
non-conforming use determination.
but being a revenue-driven use, that he needs it
Yeah.
for
Right,
revenue purposes.
And
So
that's
if he's
what I was
driving the
asking my
businesses
question
out,
based on.
If I might, just to briefly address that, because Mr. Hughes makes a valid point. I'm trying to respond to the questions that come forward. The non-conforming use is not driven by the need for revenue. Non-conforming use is driven by the fact that this was a use that's been permissible since 1976 when it was built and has continued that way. What I was trying to demonstrate is what Mr. Nacarado was testifying to. There isn't a demand for those spaces for retail. There's not a sufficient demand to keep them. It's not a decision on his behalf to keep people out of the shops so that he can have a parking lot. The problem that he's got is that he doesn't have anybody who wants to be in the shop, so he's down to 4 or 5 units that he can lease out. Consequently, he's got a largely empty parking space or parking lot that has always had paid parking there. So yes, he continues to do that, and the town is now saying, you're not allowed to do that anymore. What you need to do is you need to turn it into what's today a shared parking space or shared parking lot, which has new code requirements. There's a bunch of new things that have to be done. He's saying this is a lawful non-conforming use. It's always been this way for the past 40 years. He should be able to continue to do that under the code. So that's where there's a reason why it's important to him, but that's not what makes it a non-conforming use, which I think was Mr. Hughes' point.
No, and I totally understand his point.
Yeah.
But one of your arguments about it was the revenue.
Revenue.
That was why I was asking questions about it. I totally understand what we're discussing here, but you brought up the point of the revenue. That's why I was asking questions about it. I'll yield the rest of my questions if I have any other ones.
I was a tenant at that site, and I wish I would have written down the dates because I don't really know for sure when I sold it, but I think I sold it in 2008. And at the entire time I was there, we had hanging stickers from our rearview mirror for all employees, and for the members, I own Curves, and so I had parking things for them to come through so that they didn't have to stop and talk to the attendant. There was an attendant there because from our window, we could sit there and watch people come, pull out their chairs, their towels, their coolers, and walk across the street. If there hadn't have been a attendant there, we would not have had parking spaces for our people. As employees, we parked around the back. I am curious, with the 4 people that are in-house at this time, how much parking spaces are assigned to them for employee parking and for customer parking?
For the tenants, employees.
We don't reserve any. We never, the only time when we have a full parking lot, it's on the weekends during season. Otherwise,
Speak into the microphone, please.
Oh, I'm sorry. We never had, during the week, we never listed a lot. That bothers me. We never listed a lot, full lot, never. Just on the weekends. On the weekends, there is nobody there except Mr. Tequila. Mr. Tequila, we reserve at least 12.
But there is
A
a
dozen
number
of,
of parking spaces
spaces.
that should be assigned to each unit for the employees and their guests.
How many?
How many should?
There aren't any signed to anybody.
Okay, well, we'll get that from Jason, because there is assigned parking for a business to be able to function. They have to have so many numbers of parking spaces. So
I said, Mr. Tequila there.
that's something that you'll learn, so.
One more time.
What-
Speak in the
even-
microphone,
Even
please.
if you sign that to the
Okay.
tenants, to the tenants and this and that, sign the parking spaces. If we're not there,
I realize that. I
assign
understand
the
that.
parking spaces, they don't care. They park,
I understand that.
She said that.
I understand that. I
Yeah.
just was asking the question of your tenants, how many parking spaces do they use for their personal employees, and how many are required for their business to be in use? That maybe can be answered by Jason, but he probably can't answer the number of people who are employed by these people at the same time. But I will state that at the time that I was there, for the 6 years I was there, there was a attendant during, not during the summer, I don't recall during the summer, but maybe on the holiday weekends, there was someone as an attendant in the parking lot. But they were definitely there during season, and they definitely did charge a minimal fee to park there.
Peak times, like our code states?
Huh?
At peak times, like our code states?
Well, during the entire season, they were there,
Okay.
and consistently. And I can testify to that. I was there, I acknowledge that, and we had hangers on our rearview mirrors for the people who had memberships at Curves to be able to come through and not have to speak to the tenant. So I think the key thing is there are also trash compactor or trash things that aren't blocked out on your site plan. I think maybe 2 to 3 parking spaces take up the trash things. And
Do you have a question for him?
well, that
Okay.
reduces the number
Okay.
that are available. So that was my only thing. I think that we do need to come up with what it requires. I do think there is a use for it. So I think I'll wait until after he speaks to find out about the number of parking spaces required.
Dan, do you have anything?
Well, I have a basic question here. If I would like to address the council and the staff, what specifically is the issue that we have to decide today? It's my understanding that it's a request that they be determined to be a non-conforming use. If we answer that in the affirmative that it is, this other discussion's irrelevant.
That is correct.
Yes.
So the issue before you is whether or not the applicant, at the end of the day, whether or not the applicant has proven by competent substantial evidence or preponderance of the evidence that this was or that this is a legal non-conforming use. And I think, certainly after you hear from staff, you obviously will have to make that decision. But the issue from your perspective is the applicant is saying this was permissible and has happened. Our code, and the question before you is, was it actually permitted as a commercial parking lot? Because I think the evidence that I've heard here this morning is that while it was originally permitted as a retail or office use many, many, many years ago, what appears to be the primary use of the property right now is as a commercial parking lot. So what was it permitted back 40 years ago? Was it permitted as a commercial parking lot, or was it permitted as a retail establishment with associated parking?
I feel like the questions that we have been asking is to determine if this is the primary use of this or not, whether this is an office building or not, or is this a parking lot business, which is what the questions I feel have been asked here. Of what is his primary business of record and what was permitted?
No. The
No?
issue is whether or not the applicant has demonstrated to the point where you agree that a commercial parking lot enterprise was legally established on this property prior to the town's current regulations going into effect.
So isn't that what we're trying to do, is to establish if this is a commercial parking business now, or is it an office building with parking and excessive parking being sold?
But
It could be both,
No.
technically.
it theoretically could be both, and I think that is the suggestion that is being made by the applicant, that it's always taken place. The question that as in your code and is looked at by the courts is whether or not it was legally permitted as such. Not that it could have been allowed under the old regulations, but was it in fact permitted as a commercial parking lot? Whether exclusive of the retail or in conjunction with the retail.
And just as a point of clarification, because I think that does help to focus, my one disagreement with that statement would be the point about whether it was permitted in terms of, was there an actual permit issued? Back in 1976, that's not what Lee County was doing. And that's the point I'm trying to make with regard to the long-standing use of daily paid parking out here. As a commercial, where the commercial parking lot was a permissible use, as the code showed, it was permissible. Even though it wasn't a strictly commercial parking lot, we submit to you that the county allowed that to happen, allowed that daily paid parking to take place because it was beneficial to the town, and it was also beneficial to the property owners to allow that to happen. And so, although in 2019, it's very clear what would you allow as a shared parking lot or a commercial parking lot. Back in 1976, they weren't that sophisticated. They were allowing daily paid parking to take place and to be monitored on less than an assigned basis. In other words, does the site plan show these spaces are assigned to those uses? No. They simply allowed that to take place, and it's continued that way. And that's where I want to make the distinction between whether it was permitted, where an actual piece of paper, no, we can't come up with that actual piece of paper, but it was permissible.
Under the ordinance that you cited, the county ordinance in which it's the BU, commercial
BU1.
parking lot, is included as a use in that division of the code. Is there a definition of commercial parking lot elsewhere in that?
No,
There's no definition of that?
that's
But
my
you're
point.
saying there was no permit required. There was no CPD in those days. There was no permit. There was it's just that it was a use that was included within the framework of a BU zoning district.
Yes, sir.
I would defer to staff, but that is not the case.
Okay, well, that's what I'm trying to.
You need a site plan, and before
Yeah.
any use can be approved, even, 40 years ago, there is a site plan requirement. There's an approval requirement. There's a list of permitted uses, and you have to apply. I mean, the analogy that I hear being made, or analogy that I would make from base what I'm hearing, is that I could build a home that is permitted in a residential zoning district and convert it into a bar because that was listed as a use, even though I never got a permit for it. And I started, inviting my friends over to have a beer every Friday, and it eventually turned into a commercial enterprise over the years in my garage, and now I'm legally entitled to continue to have that bar, even though I never got it permitted. And that's not what our code says. and nor does what the law says on non-conforming. The courts have said you have to show that not only could you do it, but you obtained approvals for it. And that's my instruction to you as your attorney.
And again, to follow the analogy that Mr. Herron has made, if in fact you built a home in a district that allowed both a home and a bar, and when Lee County recognized the bar as a permissible use, and it started being used as a bar, and people are coming over for drinks, and the town incorporates, and the town then comes up with a whole set of regulations that says, if you want a bar, you have to put landscaping in the front, you have to have this many parking spaces for it. But it has been permissibly used. Lee County didn't stop that. Lee County didn't prevent it from happening. It was permissibly used, and then the town regulations changed it. I would submit to you that, yes, as crazy as that analogy is, or example, that's a non-conforming use. It was a use that was permissible. If you look back at your...
Our code says it's a use that was lawful.
Yes, that was lawful prior to the adoption of the ordinance from which this code was derived.
And that's my point. I'm sorry. We're conflating lawful with permissible, and that's not what it's lawful is you obtain a permit. I'm not disagreeing with Mr. Hartzell's analogy about the residential being, but if that residence was permitted as a home, not as a bar, even though it could ultimately have a bar, what I would have to do as the owner of that home, I'd have to go back to whatever the jurisdiction is, whether it's Lee County or the town of Fort Myers Beach, and apply for the right to have the bar. And I think I don't think that there's been any testimony from anyone that or any evidence from Lee County that this was actually permitted as a commercial parking lot. But that's ultimately for you all to decide.
You good? You have more
Well, I'm
questions?
still troubled with whether, if that's the standard, that it has to be permitted, but if the county didn't require a permit at the time. I'm troubled
We can
with
get to that if we can get through
Yeah.
the questions.
But
We'll just get through
again, let me address
okay.
that issue legally.
Okay.
Just because it happened does not mean that it gets grandfathered. The law is that if something, you can potentially raise the issue of latches, but there is a case, several cases, one out of the 3rd District Court of Appeal and one out of the 2nd District Court of Appeal, that says there is no statute of limitations that applies to code enforcement violations. So if this property was being used for 40 years illegally, it doesn't mean that it becomes legal all of a sudden. The town or any jurisdiction could then initiate code enforcement action because under the definition of code violation of state statute, each day the violation takes place is a new and recurring violation.
Tim?
Couple questions. In your presentation, you show a illustration of all the parking spaces that's basically listing 135 spots?
Yes, sir.
Okay. According to this illustration, you still have an opening onto Estero that has been closed off by vegetation. And I'm not mistaken, but I believe that your entrance to the parking lot is not off of Carolina, it's off of Estero. Am I correct in that?
Yes.
If that's the case, then this illustration and the number you have listed here is an incorrect number.
Was intended to be illustrative of the number of parking spaces. If there are fewer parking spaces or more parking spaces than 135, we were attempting to just show how many there were.
Okay, just bringing it into record that this illustration and this number may or may not be correct at the
that's
time. My next question, can you answer how many days per year we use this parking lot as a paid parking facility?
It's available, all of those, I mean, all year round.
So he uses it 365 days a year as
Well-
paid parking?
I don't know how many days, I mean, with regard to how many days he's actually got an attendant out there.
Maybe he can answer.
Yeah,
7 days a week.
7 days a
Microphone.
week, 365 days a year.
365 days a year,
speak into the microphone.
Okay. What I want to know.
and I have to. I don't want to be there. I do a lot of them
Well-
myself because I'm not generating enough, revenue there, and I'm there in 5, 6 days a week in season, 7 days a week myself, try to save a
Okay.
little money on labor.
To me, there is a difference between having a parking attendant to prevent people from parking there for a business use. But there's also a difference between having someone who is there collecting money as a revenue stream for the parking. So my question is, as a revenue stream, how many days a year do you operate
As a
Think you
parking
just-
business.
as a parking business?
Like I said, that we make a little money January, February,
Into
and
the
March.
microphone, please.
In March. The rest, we gotta be there because we gotta be there. Otherwise, people, they're gonna park there and they'll go to the beach, they go here, they go there, and when Mr. Tequila opens up at 10 o'clock, there won't be one parking available for them.
Let me maybe ask the question. When you're there monitoring the parking, if somebody is not a customer, do you charge them to park there?
Yes, sir?
And that's 7 days a week,
Well,
365
you
days
have
a year.
to.
Okay.
It's a headache, sir.
Yeah.
I wish
all I
I never
have.
bought the property.
All right, Scott?
And just a follow-up to Mr. Smith, on your slide number 7, one of your points was may be rented to the general public during peak seasons. And then on page 12 of the affidavit from Yvonne, number 3 said that she had the parking lot by renting spaces on weekends, holidays, and for special events. If I let my kids to have their friend over on Friday nights and for Christmas, and all of a sudden they're over there every day, don't you think the deal kind of changed? That what you're saying is that the county gave us a permission, we're going as is. I don't feel that you're going as is. I think you're doing things differently than what the intention was. Would you agree or not?
No, I wouldn't agree. Again, if you go back to what the county allowed it was permissible, and I would submit that if it's permissible and the county's allowing it, it was lawful. They weren't prosecuting it, they weren't stopping it. Again, because it's the kind of use that is sort of unlike the house and a bar, where you go, it's either a house or it's a bar. In this particular instance, they had parking spaces that aren't being used by the tenants for the last 40 years. And consequently, you have to have someone out there to stop people from parking for free. So that attendant who keeps people from just, using up all the parking spaces, that attendant charges people. And I submit that the county's commercial parking lot permissible use was viewed by the county as, okay, you could have a commercial parking lot there, you have extra parking spaces, somebody's out there having to charge or turn people away, and that's allowable, that's lawful. Did they actually get a use permit or something? I don't know, don't have records to show that. It's difficult. But after 40 years, the problem that we're facing is that now Mr. Nacarado is being prosecuted for something that at the time he believed was lawful. It had been done this way since the county regulations were in effect. And that's where I would respectfully disagree. Mr. Barron has his view, but I do believe that when it says it's a use that's lawful prior to the adoption of the ordinance, it was lawful. That's why it wasn't prosecuted. And what changed is, yes, we're more sophisticated now, but it's still necessary, and it still provides the same function.
I think and clarify what he was saying, what he was clarifying is that 34-219 in our code states that it may be rented to general public during peak hours. And from what looks like from the affidavit that you submitted, that was actually being abided by the previous owner. And now, according to what he's saying, it's the 365-a-day business, which really doesn't meet the non-conforming. You turned it into something that beyond what the original use was, which means it's not non-conforming. That's where my head is going with this. So I guess that's, when did it become a 365-day-a-year parking business versus what your affidavit states here was a weekend and special events? Our code says weekend special events, which conforms. When did it become non-conforming?
As you pointed out, somebody has to be there as an attendant. If they're not there, the parking lot fills up. So it is a daily activity of having to have an attendant. In terms of just saying it only happens during the peak season, if you don't have any parking spaces for your tenants, you're out of luck. That's why our point is that, yes, it's always peak season. That's where it's necessary to have the attendant there. Mr. Nacarado wanted to. No,
Nope.
you have to speak into the
Listen,
microphone.
what I do have to say, okay, I mean, I don't want you guys to say, hey, okay, this is very, very, okay, touchy situation. Okay, here is Scott Stanford, okay, he's got a little business across the street. When I started blocking the entrance away with cones, I got a permit from the fire chief. I got a permit from the police and everything to close until I got my permit that I can close that entrance permanently. What he did, him right
You know
here.
what? No.
He
I'm
grabbed
going to stop
the
you right
cones
now.
and he
Sir,
got-
stop
he put
him.
the cones in the
No, I
dumpster.
got, please
He
back off.
still, to this
Do
day,
not,
every
no.
time- Every time I'm in the front,
Mr. Sappert has
he
kept it
goes
respectful.
by.
You
He
please
goes
keep it
by.
respectful.
He calls me, hey, asshole.
All right.
That's why we're here. Because of this guy.
Stop. Please.
Sit down.
Okay? That's why we're here.
Sit down.
Okay?
Now, he's kept it respectful. He's asked one question. We asked the same of you.
Asshole.
Just a-
All right.
Please call.
Please, please leave. Please.
I rest my
please.
case.
No, sir.
Take a break.
Take a break. We're going to take a 10-minute break. We will take a 10-minute break and we will adjourn in 10:20. 10:14, we're calling the meeting back to order.
Madam Chair, I apologize for the outburst and for any offense that may have been directed personally. I want to, it's apparent how emotional Mr. Nacarado gets because of this, but that doesn't excuse the outburst, and we apologize for that. It's not going to happen again.
Thank you, I appreciate that. I'm going to go to Jane. Any questions, Miss Jane?
I'm going to wait.
Okay.
The town presents.
Any other questions of our applicant at this time?
Yes, I have one. In addition to the language in section 3202C, which defines nonconforming use as a lawful, which was lawful prior to adoption of the ordinance and so on, and you somewhat equate lawful with permissible, but I bring your attention section 34-3242, which deals with enlarging a nonconforming use. And at 34-3242A said no such, let's assume that you're correct, that it is a nonconforming use. Just make that assumption. But then 34-42 says, no such use shall be extended or enlarged, and on A3, by increase in the size or number of vehicles and boats, or increase in the capacity of services such as parking lots that would expand the operation of the nonconforming use. In other words, I think the testimony has indicated that there's been a definite expansion of the nonconforming use and a totally different activity or scope of activity from the original adoption of the county ordinance and the acquisition of this property in the year 2000 and 2001, or whenever he acquired that. This was a very viable operation, and most of the units were rented and so forth.
He acquired it in 2017.
Well, 2017,
Yeah,
well,
it was a viable, I
yes,
hear what you're saying. Okay.
whatever, okay. And so I just would like to know, what is your response to the fact that there seems to be an expansion of what was the particular activity that we're referring to here, with parking for commercial, paid parking, an expansion of that activity?
Yes, we would submit that the expansion that you're talking about would be adding additional parking spaces, say in the open areas or in the retention areas, or somehow adding additional parking spaces would be an expansion of that use. But in fact, what's happened is, what was permissible is any parking spaces that were available that weren't being used could be used for paid parking. And it wasn't limited to, you have 50 or 75 spaces that can be used for paid parking daily, and you have X number of spaces that have to be left open for customers. That was just done essentially by the attendants. They kept a number of parking spaces available so that the tenants and customers had parking. Whatever was left over could be paid parking. And so it was a flexible number and continues to be a flexible number. The problem Mr. Nacarado has, he's got more parking spaces than he's got tenants right now. So that's the...
Well, okay, your interpretation is, I understand your interpretation, but I think it's arguable, you know.
One quick question. Your client had said that the occupancy rate is currently 4 out of 28 potential shops. What was it when your client acquired the property?
I'm not sure what that was.
What I think it was,
And please, up at the microphone.
there was, let's see, 1, 2, 3, 4, 5, I think 5 or 6 more.
Thank you.
5 or 6 more than the
They were,
4
they
you
were, they
have.
were all peanuts. They were just,
But the
No,
question
for the water
is,
bill.
the total number when you purchased, not,
yeah,
so
they were,
is there
they were
6
5
more
Yeah,
than
they were
the
about 9.
9?
Yeah, right. But like I said, they were, I rented their rent, and then they had no lease, and so they all left.
Thank you.
Thank you.
Any other questions for our applicant? Jim, Dan?
Not at this time, no.
All right, so I would like to bring up the town.
Hi, good morning. Jason Green, Community Development. I'm going to try to address a couple items, and I think what we'll discuss is really in step with what the applicants kind of basically alluded to, is that I think what you're getting a taste of is there's a moving target here, and that's part of the issue behind all this. But more importantly, they've provided the documents that they provided in our review did not establish the lawful establishment of the commercial parking use, and that's a critical part. Packet page 25, they've provided a list of the, I guess, the BU1 zoning uses. And you know, when we do zoning, you're not allowed and permitted to do any use that's within that list. There are still steps that are required to do those uses, whether it's through a use permit, a conversion of a physical space that requires building permits. There's other steps that have always been required. For example, automobile washing, gasoline service station. These are not uses that he could have just turned around and done because it was allowed in the zoning district. So the fact that commercial parking lots is a listed use doesn't mean that they were grandfathered in or permitted to do that lawfully. Second part to that is, originally when we met, we had this discussion to have this path to be able to get to pass basically staff if they didn't want to do the other applications, which has been, this whole conversation has been ongoing for 18 months or more. Originally when and I don't have it unfortunately because the applicant brought it in, and they've changed their materials, but what they've chosen to include is what looks to me like a page from a building permit, because there's an architect signature on it for the Kia Estero shops. And I think it was pointed out that obviously that layout and site plan does not match current conditions today. What I saw was what seemed to be a page, which we don't have, from a development order sheet, which outlined number of parking spaces based on commercial and retail square footage. I believe there was actually some surplus additional parking spaces. I don't recall the numbers, but it looked more like a development order. And my comment at that time was, to me, this shows clearly that it was for retail commercial at the approval of this in 1975. Doesn't say anything on these sheets about commercial parking lots. So without that, now between then and before the town incorporated, sure, there could have been some approvals for that, but there's no documentation. There's been nothing provided to us to clearly establish that, and that's why we've had to disagree with their assessment that it has not been lawfully established. Other evidence that shows a use permit or something like that, perhaps. The problem that we've had is, in the conversation that I've had with the applicant and property owner, is you know, it's a moving target. You haven't established how many of these spaces are for parking. Surplus parking is defined in our code very specifically. If you have 10 or more spaces that are extra, then you can apply for the surplus parking component. There's also a commercial parking lot where that could become the primary use. None of that has been done, none of that has been requested, and we don't know how many they're using from one day to the next or for the last 20 years. And I think as you've highlighted it already, that number has probably changed as the available spaces changed. Per our code, there's still spaces that need to be allocated per those retail spaces. My thought was through the special exception process, through the variance process, we could establish that, so it makes it easier on everybody to know, whether it's 50%, 20%, whatever it might be, that we know on a day-to-day basis how much is being allocated to those uses if that was approved. But again, none of that has been documented, and Mr. Hughes made a very good point about 34-3242 about the expansion non-conforming use. That's exactly why it's a challenge to define how many spaces were for parking, and whether it was an expansion. It appears to be an expansion of that use, even if they were, how many were they originally approved for? And nobody's been able to answer that. I find it hard to believe, based on what we've seen, that they're approved for commercial parking on all the spaces and the retail for the parking spaces to satisfy that retail. So without other further evidence, we've been unable to agree with the applicant's assessment that it's a lawfully established use based on our code and definition of legal non-conforming uses.
Jason, you said that you thought you saw a development order?
Yeah, there was a packet that was brought in. We had a casual conversation about what the process was when we agreed to, it was not a submittal, it was not an application. It was just, here's some documents that we've had, and some of the aerials were included. We'll try to look for that. I don't know where they got it from. Some of these old documents are hard to track down, so I was impressed that they actually had something. But we're going to look for that before the council, I can tell you that, because I believe it was a development order from the 1975, 74, some of that time frame that showed parking calculations for the retail use, just like we would today. If somebody came in with a restaurant, whatever it was, they would show the square footage, they'd do the calculations over in the corner, and then they'd show them on the site plan, obviously, and number those.
In that regard, obviously a prior development approvals by Lee County, or for that matter from the town, would obviously be the best evidence of what has and hasn't been approved for this site. And again, I'd reiterate is that it's the town's historical interpretation application of the non-conforming lawful is not synonymous with permissible, but rather lawfully established.
Well, wouldn't that development order lawfully establish that as well, that was what was the intent of this?
Of course, but we don't have that.
We don't
and
have
my
it, and
my
they
last,
haven't submitted it.
and it's the applicant's responsibility to demonstrate to you all that they have established and they have a legal non-conforming use. It is not staff's responsibility to disprove that, but the fact that it exists and it's not in the packet, you can deduce from that whatever you want.
And I will say, again, non-conforming, conforming, all those things, they may even have additional parking per our current codes, because our current codes have a discount in the downtown versus what I believe Lee County had previously. That may open up more spaces for them by our code, to meet our code for the retail and commercial side of it, and also to do that additional use. But again, that has not been established, and that process has not been taken on to do that and get those uses.
And you have a question?
Okay, I think we can all agree that there is a non-conforming use that has gone on since Lee County, whether it was legal or or not legal. But if they changed from getting a determination to use as a commercial parking lot and just went with the LDC 34-2019 parking spaces or parking lots with more than 10 spaces, couldn't they apply by bringing in the parking spaces that are required for what they have in use and get a calculation on that of the excess parking, and then for each use that comes in to occupy a new space, reduce the excess space each time somebody comes in? With that being said, wouldn't they qualify under that?
There's an application process, including whether it's special exception and or variance, because obviously the landscape issue with parking lots has been a conversation for the last couple years, I guess. Yes, there's a process for that. I don't want to jump ahead to that process, but I would guess that we would look at what is it needed for the amount of square footage of retail versus what is needed for what they want. And my guess is those two things are conflicting with it, right? They want to use, but yes, there's a process that we could set aside retail spaces that are required by the code, and then that would leave a balance potentially for a commercial parking lot if that was approved.
Okay, because as you said, the finding the paperwork for when this was developed may be an issue.
I'm saying I saw a development order sheet that they have gotten a copy of that had the calculations for retail and did not have any mention of commercial parking. And my statement to them was, if this was approved for commercial parking, I would have thought, as we still do today, that use would have been listed on there, how much of those spaces were being allocated for that. And that's not what had occurred. So maybe it happened between then and now, very much so.
Okay, if they can't come up with a commercial parking lot,
we don't have any evidence to show that it was lawfully established. That's my
then
point.
wouldn't the easiest thing for them to do would be to apply for that 10 parking spaces or more and have that defined?
The testimony staff has had that conversation, and it's on the blue sheet, or I'm sorry, your yellow sheet, that they've been advised of that process. For whatever reason, they've elected not to pursue that avenue, but rather come before you all or challenge staff's determination that they don't meet the non-conforming definition. That is why we're here. They can withdraw this application and pursue that process, which has been explained to them, but you would have to ask them why they have not pursued it.
And I would be happy to address that.
Okay.
It
That was my
is-
question. I was trying to ask before,
Thank
but
you. It is confusing in terms of what process. As Jason has pointed out, there are questions about whether a variance is required, whether a special exception is required, how 34-2019 is applied, because it would seem to me anyway that 34-2019 is independent. It doesn't require a special exception or doesn't require a variance. Frankly, in preparing for these hearings, and I do appreciate, I met with Jason, and it is challenging. It goes 40 years back. Staff, I understand the position that staff has taken, but I appreciate that when staff looked at this, they said, we can go to the code enforcement and we can just deal with it strictly as a code enforcement matter. My defense, or Mr. Nacarato's defense to that, is that it's a lawful non-conforming use. Honestly, the code enforcement board or special magistrate is not the place probably for that kind of a defense to accurately. And staff and Jason said, look, take that to the council, to the LPA for a recommendation, make your case to them. They deal with these matters. They gave us an opportunity for that. But if 34-2019 is an application that says, here's where your parking spaces are, here's what the parking spaces would be, and recognizes that that building in use is there, we're not going to have to redo a bunch of landscaping and kind of bring everything up to present code, that may very well be an opportunity if the council determines that this is not a lawful non-conforming use. So we do believe that it's a lawful non-conforming use. If that turns out not to be the case, then...
You have the development order that he stated that you submitted? Or you showed him that had this on there?
I don't have that with me now, and I vaguely recall what Jason is referring to. I had a number of different site plans, and that didn't relate to the non-conforming use issue.
Dan, I'll start down there. Do you have any questions of the town?
Well, this really boils down to the interpretation of the definition of nonconforming use, in my view, and we have our council indicating that lawful means not only permissible under the category of the zoning district, but requires a permit. Counsel for the applicant has a little different approach. He says there was no permit required. So, but as I said earlier, accepting the argument of counsel for the applicant, I still have trouble with section 3242 on the enlargement. And Jason, I assume that that's not in your staff report because you would come to the conclusion that it was, in fact, not a lawful non-conforming use. So then 34-242 on enlargement of that becomes irrelevant and not necessary to take that position. Would that be fair?
I think that's accurate, and I think, if that finding was to be made for the establishment of the use, then we still run into the issue of the point that you made of 3242. There's still an unanswered question there. But yes, that's why we didn't address that specifically, because the use wasn't established by our review of the material.
All right, so then, in my view, you get to another interpretation of that section, and that's arguable. That's something we have to decide.
I have a question based on what Dan just said. And I read what he brought up about, or I took as 34, 32, 42A, to mean that if they expanded the uses of parking spaces and took other areas away, like if they took the pond out and made that parking, that would be expanding the parking spaces. The parking spaces are already there, and they're just using for different spaces because the units are not full and are not requiring the use of them. So that is how I read that it wasn't expanding the use because the parking spaces are already there. It's just that the map doesn't actually create the flow that comes in, and the spaces that were, the ingress is
Says the
actually
capacity, it says
add
the
more parking spaces.
expand the operation.
Does the town have a comment on this?
As the LPA attorney, I believe that is, in fact, the correct and proper interpretation. As I previously stated, what the evidence that I've heard is that a retail use with an associated parking lot that was approved 40 years ago is now, for all intents and purposes, a commercial use. There has been a change in use, an expansion of the commercial component, which may have been a very small, if at all, at the beginning, and has now swallowed the entirety of the use of the primary use of the property. So there has been a change that would trigger that provision, but as the staff, as Mr. Green has said, staff didn't get to that point because it didn't get past the initial threshold determination that it was a non-conforming use to begin with.
Do you have any questions for the town? Scott, do you have any questions for the town?
No.
Jane, do you have any additional questions for the town? Dan?
No, I think she covered it.
Nothing further.
Okay. Any additional questions for the applicant? Okay, I'm gonna open it up to public comment. All right, I'm gonna close public comment. All right, so we're open for discussions amongst ourselves. Anybody have any comments they'd like to make on this? Thoughts?
I think you've heard my analysis of the situation. To me, I'd like to hear what the other people feel about the issue of the interpretation of 3242.
I feel it's become an expansion of it.
Yeah.
And even in the affidavit that was originally submitted stated that they only charge for parking during peak times and during weekends and holidays. And this has been expanded into a full-blown commercial parking lot business and less of what so I don't find it's a non-conforming use.
I would like to ask if I can think of another example where this seems to be the same situation, and if there is an issue with their parking lot or if they have permits for, would be the paid parking lot and attendant on site at the Lani Kai. They charge for parking every day, 24/7.
Parking lot, the parking lot
And-
across the street, and the parking lot down the street.
down the street.
I have not reviewed their approval, so I can't comment. I don't believe they're under any code enforcement action, but that's something I can research before council to see if.
Well, I mean, it just seems like it's the same kind of setup with excess parking and needing an attendant to keep parking spaces open for the people using the building. And so I would think that,
Well, I don't know I
Okay.
don't know the permitted approval, approvals that went with that site, so I'd have to research
I
that.
have a question for you, Jane, though, because you said that you said that you used to have a business in there. When the attendant was there, was it to stop people from parking there and going to the beach?
yeah.
Or was it to charge them so they could park and go to the beach?
both.
Okay.
It was to stop them, direct them where they could park, so there would be parking up front along the lake for the people who are tenants, and if they weren't going into the place, they were charged to go to the beach.
So becoming a full-blown parking business would be an expansion again.
Well, it's the same thing, it's just they're doing it more days of the week.
Yeah, comment?
I have just one more question for this that occurs to me. If we come to the conclusion that this is not a lawful non-conforming use, what variances would specifically be required?
So, Jason Green, Community Development. Probably several, because, again, I don't know the layout of the site. I don't know the width of the aisles. I don't know the width of the length of the parking spaces. Our code for parking basically requires the parking lot to come into compliance with current codes. My experience here is most of the, what I'll call existing commercial parking lots, or whether they're for a retail business or on their own, don't meet current codes. Landscape buffers are an example of that. So those are the types of things that they can apply for a variance to those technical standards, instead of having to, reconfigure and redevelop the entire site. So landscape, generally it's aisle widths and parking space size, angle, sometimes 45 versus 60 versus 90-degree angles, landscaping, that type of thing.
Mr. Hughes, I can tell you that based upon, assisting other municipalities and private clients who have faced this issue, one of the most common requirements to bring up to code is if you have not repaved your parking lot in the last 5 years, the ADA requirements of how the ADA stalls have to be laid out has changed, and that is off the top has to be brought into compliance. That right there is and it can't. That's one that, by the way, variance can't be obtained for, but that is a requirement that virtually every parking lot that is undergoing restriping, reconfiguration has to meet, because the ADA requirements for parking stalls has changed in the last 6 years. And so if you haven't upgraded your parking lot during that time frame, that's when you're definitely going to have to implement.
I think they had handicap parking spaces when I was there.
No, it's the
down at the
size
restaurant.
and
Yeah.
location, and where they're at and how many there are has changed since then.
Okay.
All right. Any other discussion amongst us? Do I hear a motion? All right, then I will do a motion. Let me see here if we've got more information here. Does it have to be of a? I'd like to make a motion that I move that that from the findings and testimony today, that this is not inconsistent with a lawfully non-conforming use of the property of 16, that commercial parking is not a lawful non-conforming use of the property of 2936, no, what's the address here?
1661.
1661 Estero Boulevard.
Second.
All in favor?
Aye.
Opposed?
All opposed?
Aye.
Motion passes 6-1. Thank you.
I would like the record to show that I voted favorably, but I think it's questionable whether it was originally a legal non-conforming use, but I think they lost their non-conforming use under 3242.
Let the record state that, reflect that. We'd like to take another quick break. We have a member that has to step out here.
11:15, but
Okay.
whatever works best for the chair.
Then
Dan
we'll-
has to leave at noon.
Okay, then we're going to keep moving, and if you need to step out for your phone call. Okay.
A brief phone call I have to step out for. Yep.
All right, moving on. I'd like to open the public hearing for DC 1-201-90073, rezoning of 2639-41 Estero Boulevard.
Good morning, Jason Green, Community Development. This is a request to rezone, as you said, property 2639, 2641 Estero Boulevard. The property is owned by the town of Fort Myers Beach. The future land use is boulevard. The rezoning is residential conservation, being requested to be rezoned to institutional. This is the piece that was acquired and is being viewed and studied as part of the Bay Oaks campus, incorporated as part of the redesign or the master planning for that. Based on our analysis, that the rezoning to institutional, obviously it's adjacent to the Bay Oaks campus right now, which is also institutional, is along Estero and provide a potential gateway or use but for public facilities. And the use of institutional is specifically for that type of use, whether it's parks or cultural facilities. So based on the review of LDC Section 34-85 and the considerations outlined in there, staff finds that it's consistent with those requirements and requests for approval, recommendation of approval to the town council of the rezoning of this property.
Town is also the applicant, so we'll just open it up for
I
questions.
won't give another presentation.
Thank you. The town is also the applicant. We'll just open it up for questions to the town. Dan, do you have anything?
No, I think it's a wonderful addition to have this come about. And I understand what faces us today is just the rezoning, the specific use as in the prior situation. There's a difference between just putting in the rezoning and what the actual use is going to be, and that will require further action by the town when they come to some decision, right?
Correct, that's a valid point. There's no development that will occur on the site until other permits are acquired.
Obviously, I've lived here too long. I used to live at this property when it was a threeplex. I lived on the second and third floor for 1 year after I sold my hotel and waiting to purchase a home. So I am very familiar with the property. It looks a whole lot better than it did when I lived there. And
Was that because you were living there? Or?
no, I think it was condemned when I moved in, and I
Okay.
had to make repairs to make it accessible to live in because it was in February and there was no place to live. There was a swimming pool on the second floor, so inside, catching the water from the roof. But we removed that. Anyway, the question I have is, the question I have is, will there be an ingress to go back to Bay Oaks and the pool from Estero Boulevard?
I don't know that yet. That's in the
Oh.
master planning phase right now.
Okay. All right, well, then I have no other questions at this time. And I think it's a great use for the town, and I hope that they will use it to advertise better for the use of the tourists and the people who live on the island to use the facilities behind there, because I don't think it's real visible what's there.
Dan, do you have a question?
Cut me off? Fine. 3 minutes.
No, I do not have any questions. I agree. It's been a long time coming. I was recently on the Bay Oaks committee, and we worked very hard to come up with what has now been approved as a strategic plan. So I'm looking forward to seeing what happens.
Questions?
No questions? I have no questions either. Any public comment? Opening up for public comment? No public comment. Closing public comment. Any additional discussion amongst our members on this property? That would be a great time to tell us all your fun things about that.
Oh, sorry, I'm done.
Is the road by the school still going to be there, or you still haven't figured that out yet?
Again, that's all master planning, what the uses are and what the layout will be.
Okay.
Okay, do I hear a motion?
I so move. I move approval of the property in question from residential construction to institutional.
I second that, but it should
Based
be
off the findings and
conservational, based on the findings, yeah, and conclusions.
Based on also that the proposed rezoning is consistent with the comprehensive plan.
Do I hear, and then you second it?
Yes.
All in favor, say aye.
Aye.
All opposed, say nay. Passes 7-0. All right, next we'd like to open up the public hearing on the text amendment to the LDC sections 34-638, 34-631, table 34-3, and figure 34-1-A. Recommend approval of the proposed edits to the land development codes. Town is the
Morning.
applicant.
Good morning, Sarah Probst, Community Development. We have had several discussions about this at the joint sessions with LPA and Council, so we're bringing forward some requests for information, feedback regarding what we've come up with. At the discussions, we discussed two options for height. Okay, let's start at the beginning of the staff report. So we talked about setbacks. There was a desire to change the required setbacks to increase them. Staff came up with an option. We'd like to know how you feel about that option. It was for lots less than 55 feet wide, 7.5, which is our current setback requirement. For lots wider than 55 feet, it would be 10 feet. Do you want me to do this as a
would just keep
presentation
going.
or as a back and forth?
I would think let's go through the changes. I think we all have got questions on this that, they're highlighted and questioned on everybody's paper.
And
so-
just a quick point, what that change does is eliminates that 10% for the non-conforming lots issue.
Yes.
Okay.
The next item that we discussed was regarding the porches. Currently, we're getting a lot of 2- and 3-story, the full front of the house is a porch that ends up as a flat facade much closer to the road. They're only required to have a 15-foot setback from the right-of-way as opposed to the 25. Staff made two recommendations, or provided two options. One is to only allow a single-story porch accessible from the first living level, or to completely remove that allowance. I know in the discussions, it was brought up that that should no longer be an exception to the setbacks, but we thought we would provide an additional option that would allow for porches, but just not the 2-story stacked porches that create a flat facade close to the right-of-way.
Jane Plummer, for the record, would it be a possibility of, instead of saying only on the first floor, that it could be either the first floor or the second floor, not both, or not?
What we provided was a single-story accessible from the first living level. And I think the reason is because if you put it on the second living level, then you kind of have this overhang much higher, sort of towering over the street.
Same effect as today.
Well, and it feels like it's sticking out further because it's going to be much higher, especially if you're talking about the beach side. I think that it would create sort of an unpleasant feeling, sort of an overhanging.
Well, it would probably be more used on the bay side of Estero Boulevard than the beach side of the boulevard, because, of course, the height and the view would be from the third story. The first story is probably not much of a view, other than the buildings across the street.
They could have it. They just can't go 10 feet into the right-of-way. They could still build one. You just have to build it a little further back.
Well, and typically these are used as sort of entry porches. So, the stairs up to that first living level, that's how people are accessing their, that's how we're seeing them the most. So it doesn't really make sense to have that allowance when it's not the entrance.
I see.
But that was our recommendation, there was two options, and certainly you guys can provide us additional options if you think that neither one of those are what you're looking for. And I would like to point out that the strike-through underline section that was provided for porches, Jason and I were sort of working on this, not in the same office at the same time, so he had struck through the non-conforming, which had to do with the lot width, not the porch section, which is above it.
So that would strike through B, portions of B, that would, or unless you wanted.
The 2B is what you're saying.
Yeah, 2B would be
'Cause I have that on my thing.
the section that would be revised as opposed to the 4A, which has to do with the non-conforming lot widths.
Okay.
And then the third item that we included is the height, and this was one of the biggest issues. So originally, I had proposed, I'm calling it the sticks and, I'm referring to it in two ways, the sticks and carrots option and the daylight plane option. So the sticks and carrots, that's where if you bring in the second story, you get more height. If you bring in the first story and the second story, you get more height and an additional story. So instead of having a 3-story, you can get a 4-story if you bring in your setbacks, or you leave the under area open except for 300 square feet. So that one provides some options so that there are different ways to get what an applicant may want to build. Then the other option that was requested that we look into was the daylight plane option. And that is, if you look at your packet page, 58 and 59 and 60. I utilized the drawings, the illustrations that we got when we were working on the carrots and sticks option, and I applied the daylight plane angle to that so that you could see what you would get with the carrots and sticks versus what the daylight plane option would require. And I just used the longboat key because that one was brought up as a code that one of the council members liked.
On the daylight plane though, and this is a question for you, how much of a nightmare is that one going to be to enforce and also to inspect as-built? Are we going to have encroachments? Are we going to have, hey, it's 61.2, and, you know, that type of thing? Is this going to be tougher to enforce versus, is what I'm asking, is this going to be an administrative nightmare?
I think that there's going to be a learning curve initially. I think that all the local builders will have to learn how this works, but if they work in other localities, this is already a requirement in the city of Naples, Longboat Key. For commercial, it's a requirement for Fort Myers. So I think that the architects that work in other communities will be somewhat familiar with this. There will be, like I said, a learning curve, and it may require a few additional rounds initially. I've never worked in a community that applied this concept, but I've been told that it isn't difficult. I'm not really sure.
And I haven't either, Jason Green, Community Development, but I would, you know, we're trying to, remember the conversation we had in the joint meeting about the +5 and the setback of the second story, third story, all that, and it's very hard to visualize and understand, and there's a lot of words. To us, I think initially the daylight plane is a number, you show it on your plans, you meet it. We have the same issue with as-built if somebody encroached a couple feet on the second story to what they were supposed to. So that part of it's the same no matter what. I think from an administrative side, initially to me, it seems to be easier because they show it on the plans, they show the angle. If you fit in the box, you fit in the box.
Also, I think that one thing, the carrots and sticks versus the daylight plane doesn't give you as many options. It's this. That's what it is. Whereas with the daylight plane, we'll have to figure out which option they're using. If they want to get an extra story, if they want to get some extra height, how are they doing that? Are they meeting those requirements? So because there are more options with that one, it may be a little bit more difficult initially to review that way.
And so one of the things that we included on page 57 of your packet is kind of relief from that, from an architectural standpoint. That was the feedback we got in some initial conversations with designers was if you use the daylight plane, sunlight plane, whatever it's called, as just a rule of thumb, then you eliminate any architectural features on the side of the house. So there's a provision there to allow up to 25% of the roof area to encroach a portion of that, so you could have those somewhat projected windows, but it's all got to still be within the roof line. It's still all got to be within essentially the box. So it's what they said their concerns was in other communities was then you have this flat roof at a whatever 57 degree angle. There's no architectural features to that. So we're trying to allow for a little bit of that design element in there. And that number may be less or more. There's no consensus from my review of what communities like.
I think you get that from the carrots and sticks, or sticks and carrots? Or
Well, I think with the sticks and carrots, the difference is it's more flexible. There's more flexibility in that. The applicant is able to increase the setbacks to build a little taller, increase the setbacks to get an additional story. So there are more options with that one, whereas the daylight plane, I think it meets what your concerns are regarding the impacts to adjacent properties.
I really like the carrots and sticks approach, but my question is, did you guys give any thought to a carrot for limiting vegetation height next to the building, or is that impractical?
That was actually a discussion item with the town manager, that he was interested in us including landscaping in there. I think the biggest issue for us is maintaining that landscaping, and also since we don't have any requirements for landscaping now, that would be an additional review requirement, potentially permitting, and then a code enforcement aspect. So if they were to say, we're going to maintain it at this percentage vegetation or this percentage opacity, we would have to be continually ensuring that that was occurring, and that, you know, say their trees or bushes didn't get overgrown. So I think enforcement-wise, I mean, we're open to including something, but we're not sure how to do it, and we don't currently
I totally
have the
understand the
ability.
enforcement challenge. I think,
Yeah.
from a practical standpoint, if you drive down Hickory and you see Bonita,
Mm-hmm.
most of the challenge to see the ocean, the view corridor challenge is vegetation. So I wonder if keep thinking about it, because I do think the vegetation piece should be part of the carrots, but I don't claim to have the answer either, because I know it's challenging from an enforcement standpoint, but I would just continue to wrestle with that, as would be my suggestion.
And I can say that one of the issues there is the very small setbacks that they have between the property line and that edge of house. And the first proposal is increasing that for these larger lots, increasing that setback by a few feet. So that would give you a little bit of extra space. And, you know, maybe there could be a requirement to have, you know, only taller trees as opposed to shrubs, because I know that shrubs really fill in underneath.
I think that may be an option, yeah.
And one of the things I think is, again, you get into design of a residential landscape, but limiting the deviation in spacing, right? So if the more you stagger side to side, you block more of the view. So if you got trunks all lined up of palms or whatever, then that only blocks a portion, and you can leave the other portion. So wording that is, you know, whether it's DOT has some components related to that from a visibility. We in our code has some visibility triangle terminology that's used in their fences. So if you have fences that you can kind of see the spacing between them, then those are allowed, but not a solid fence. There's some terminology that's there that we could utilize. We just wanted to get your input whether to include that in the code change or not.
Well, if you can do it where it makes sense from an enforcement standpoint, I think it'd be worth considering.
On a 50-foot house, 50-foot lot, which, I mean, typically, you know, people know what the setbacks are, front, back, sides, and they have a box. Which one reduces the size of the box the most? Because the problem is with a 50-foot lot, your house is pretty small on each floor to begin with. And I realize they have the 7.5-foot setback, but some of them, way back when, used to have 5-foot setbacks. And so those will, you know, the size of a house on a 50-foot lot, I'm just curious, what size could that be now, where it used to be what?
Well, if you look at the comparison sheets on 58, 59, and 60, that gives you somewhat of an idea. The difference is the way the Longboat Key code is written, the daylight plane changes with the width of the lot. And that was one of the questions that we had for you, how far do you want to go if you wanted to do daylight plane? We don't think that it makes sense to have the table the way it's put in the Longboat Key. The angle changes like every 3 feet of width of lot. So it would be very complicated for, you know, the reviewers and for the architect designing the building. So I don't have an exact answer on that, because we would have to get some additional designs in order to determine that. But if you look at the page 58, for example, so if that were a 50-foot wide lot, I don't know. Let me look.
My next question while you're doing that is
Yeah.
that we have changed also where we're measuring the height too. So there would probably be a more, or a request to go higher, because they used to be able to, and now we're going to start to get some more conformity into the new way. Are you following me? So
It depends on which approach you take, right?
Yeah.
So
in the
we have
sunlight
not
plane,
proposed
we won't.
changing the
We
height
won't.
measurement, but where we measure to, right? So that could potentially squeeze, I
It's
think,
gonna squeeze
shorten
them
it a
down a
little
little
bit. But then again, you have the sunlight plane component, or the.
But that's where the carrot comes in, that if you do want to get back to where we were originally, you're going to bring these buildings in a little bit here and give us some more sunlight plane. For those who weren't in the original meetings, which was the intent, was to kind of,
If you're going to do the daylight plane, I would suggest then we look at, if you change where you measure to, then we should probably increase the actual height, whether it's 25 to 30 or 35 to 40, whatever that might be, to balance some of that out, because then the angle is just the angle. The other one that Sarah was talking about is definitely more of the, if you do this, then that kind of approach. And you get that back.
On the daylight plane question that you asked, Jane, so looking at the code that we would sort of propose, the 50-foot wide lot would have a 65-degree. So if you're looking at that house, it actually would, so if you're looking at page 59, you would actually be able to have less of an angle than that house provides. So it could be more upright.
I'm just thinking, looking at a 50-foot wide lot with 7.5 setbacks on both sides, you have a 35-foot width, and then to come in each time, think about having a kitchen and a living room and a dining room and no room for a bathroom because...
So a good comparison here would be, if you're looking at this page 59, the first story, so this person got the additional height on this one, I believe. Yes, it's base height plus 5. So they got the additional height, which means they brought in their second story 5 feet. So they brought in their second story 5 feet, and they're at 62. So essentially, they could go several feet further out than that. So
5 feet each side or 5 feet total?
5 feet on each side. The original,
So then the second story would be 25 feet on a 50-foot lot. First would be 35 with your setbacks of 15. The next one would be 25.
but I'm telling you that if we applied the daylight plane angle, it would be less than 5, because this drawing shows 5, and it's only at 62%. So you may be able to only bring in that second story a foot and still get that 65-degree light plane.
Saying that,
It's
you'd be able
only
to get
going
a
to
bedroom
reduce
and a
the width
bathroom
by a
on the
foot,
width.
But what she's saying
potentially.
is not going to be a full 5 feet. What she's saying is that in the sunlight plane, as we go up as the angle, if we do the carrots, they're coming in 5 feet, period. If we do the sunlight plane, they may only have to come in 2 feet from the original line. It may have to be only, depending on the house that they're building and that type of stuff. So it's not the full 5 feet. It's going to be up to the architect what that number is based off of the angle.
And I just want to address, it's not a complete question of disrespect. What I mean is a 50-foot lot, it depends on which zoning district you're in. So it's not just a 7.5-foot setback because it's a 50-foot lot. What we propose is that, but if you're comparing it to current, remember, you might have a 50-foot lot that's a non-conforming lot. Now it's got a 10%. So yes, those are being impacted because of the issues that you guys have asked us to do. So is there a loss of square footage on the bottom potentially? Maybe, but some of this is to address a critical issue, which is providing appropriate setbacks. So again, you don't lose as much on the second by increasing the setback on the side, but then you have the sunlight angle that guarantees that angle for the adjacent properties. But your question was a 50-foot lot, but I just want to make sure that's clear. They're not the same. They're not always 7.5 feet. Sometimes they're 5 feet.
That's what I said.
Right now.
Yeah.
So the first issue is, do you want 7.5 and get rid of the 10%, which we heard yes, but that's for you guys to discuss.
So where, is the 10% in here anywhere?
No.
No.
The 10% is, just get rid of this non-conforming, conforming lots. It's just, the 55 is the threshold. If it's under 55, it's 7.5. If it's over, it's 10.
What if it's less than 50% and it's a lot of record?
Less than
50-foot lot, but it's a lot of record, because you're saying in
7.5.
here. So it'd be 7.5 no matter what.
Yes.
We base it on
There's going to be lots
And
of
The problem is
competing
we're
builders.
in the RC zoning district, that already exists. In the RS zoning district, you get the 10%. And the RC, unless it's below 45 feet in width, it's still the 7.5. So most of the lots on the island, that would stay the same.
address a few minor, major issues that they're kind of stacking on each other. Minor, major, yeah.
I have a question, Mr. Chairman.
Yes,
Yeah,
go ahead, sorry.
just bring your attention on the packet, page 52, discussion 1, setbacks. Side yard, you recommend an increase from 7.5 to 7.5. I think it's 7, isn't it? It's 7 now?
No, it's 7.5 in many cases, unless you're a non-conforming lot, then it's 10%.
Okay, well, my code is 7, but
So in here, it'd be lot size dictates the setback, and just make 2 options. To Sarah's point, you've got.
so there's no change from 7.5 in RS and RC to 7.5 if they're 55 or less.
That's the first floor.
Unless they
Then you have to
were,
go in.
unless they were non-conforming lots. You have non-conforming lots that don't meet the zoning requirements, then they had a different rule of thumb.
And then below that, where you say revised table 34.3, to remove zoning district specific setbacks so that it would apply to all. So that would, for example, eliminate the 20-foot commercial setback.
I'm sorry, just the residential component that we're dealing with on those setbacks.
Okay, so where you say revised 34.3, that bold print there, you're just referring to RS and RC?
Yes.
Okay, well, that clarifies that for me.
Thank you for that clarification.
But I guess I have an old draft here. And then this, you're not making a distinction between a waterfront lot and.
The only place that the waterfront, for houses, it's the same. For multifamily, it increases. So if you're in an RM zoning district and you have something more than a single family or a duplex, then you have the 20-foot setback. If you have an RM, if you're single family or a duplex, you have the same 7.5-foot setback. That's what it is. So if you have a multifamily unit in RM, then you have a 20-foot setback. If it's, I believe it's on water.
That was 25.
Side
Oh.
setback.
It's now 10 feet, right? And
No, I don't
7.5.
believe so. I don't have that in front of me. We're not proposing a change to that. This is for single family and duplex primarily.
residential single family and residential conservation, my code says it's a 7 feet on non-waterfront and 10 feet on waterfront.
That is not accurate. For waterfront or non-waterfront, for the primary structure, it's 7.5 feet.
Well, to me, that's not nearly enough. We have there's a lot on Randy Lane right now that's probably, it's 2 lots, and they have a building permit to build 1 home on the 2 lots. The building permit is for a home that's 18,000 square feet. I don't know what the footprint is, but the frontage of that lot is maybe at least 200 and some feet. And
Very
to have
large one.
only a 7.5-foot setback to me is ridiculous on a 200-foot parcel of property.
Well, and that's what they have now. What they don't have is.
No, they have 10 feet now, don't they?
No,
No,
that's not
7.5.
correct. That the code you have in front of you is not correct. It's 7.5.
The difference in that one would be same setback, except if, depending on which option you apply, they would have to tier it or bring in the upper levels. So it's not overwhelming to the neighbor.
Because this is all going to start moving down the side streets. We're not just talking the Estero that we're looking at. Think about coming down those side streets too.
Yes,
With these big houses. What do we do to get some sunlight on the street? What are we going to do to get it to 8,000 square foot?
And there's where our struggle is, because we hear conflicting, right? Jane is concerned about the square footage of the box, and then your approach is that's not enough. So we're kind of trying to do a dual approach, but eliminate some of the confusion on the non-conforming lots and at least get rid of that 10%. So we don't want 4.5 foot or 5 foot side yard setbacks. That was the main issue.
Question about the angle. I assume, I haven't seen it in here, but I assume it starts at the base of the First livable
Did we
level?
start at the BFE?
So the way that it is measured, using the Longboat Key code, it's measured from the property line at the base flood elevation.
So it goes
So-
in on the first level of living.
Sorry?
So the angle starts.
The angle starts on the first level of living.
The
So you
way
have a bigger garage and then smaller living.
Not necessarily.
Yeah, not
I
necessarily.
mean,
The
it
higher
could
you
be,
go up.
the wider the lot, the more likely that is. But if you look at the example on, on page 58,
Right, so your bottom level
the
gets to the setbacks that are established, and then it, tiers in, moves in, whatever you want to call it, based on that angle. I mean, you can manipulate the numbers. If you want to start at the ground, then you would have
Yes.
a different
triangle,
angle,
yeah.
a different triangle, but at the end of the day, it seemed to be most consistent to start at the BFE, because that's where your living space is starting, and really your second story is starting, so.
and with the very big difference between where base flood elevation is on the island, we thought that that made a lot of more sense.
My concern with the angle approach is also yours as well, is how much you're going to lose as you go up, not just by what is automatically being cut off by the angle, but these homes that have elevator shafts in them, they take up quite a bit of space. And as you bring that angle in, you have to bring that closer to the center of the home, which takes up even more space. So I'm looking at it from the inside, how much that's going to restrict if I could build a home that's 3 stories tall, where I can place my elevator. Now I'm going to have an elevator right in the middle of my home as opposed to maybe on the one side. So that's my concern with the angle approach.
And I honestly, I mean, that's a great question. My memory is most of our elevators end up being in the center part of the home for the single-family residential, because that's your access in the center part to it. On multifamily and commercial, we get them on the outer edges to serve both ends. But I don't know that that's true in all the cases. But
Yeah, I mean,
it's a good question.
I've been in homes in different areas
Absolutely.
that, architects get pretty creative. They can come up with some really neat things, and not all of them are directly in the center of the house, but.
Make your room's smaller with it being in the center of the house. If you only have 35 feet and you have to have what? At least 6 feet for square for an elevator? No? What is it, 5?
But let's put some of this in perspective. You're talking about, in a typical example of a 50 by 150 lot, that's 3,500 square feet per floor. So we're not talking about,
Wait a minute, on what? Say it again?
it's 3,500 square feet per floor.
On a 75-foot.
On a 50 by 150 foot lot, or a 50 by 120 foot lot, you're in the 2,900, 3,000 square foot neighborhood per floor. So we're not, if the current standard, your 7.5 foot side, you said 35 feet is your buildable area and width. If you have let's say 150 foot lot or 125 foot lot, you have
20-foot
80.
front and 25-foot back, or
Okay, so you've-
reverse, I'm
You've got
sorry.
80 feet of buildable area, let's call it.
55 feet left. Out
Depth?
of 100?
You can do 40% coverage on the lot. So if your typical 6,000 or 7,000 square foot lot, you can do 3,000 square feet per floor, basically.
You only have 55 by 35. That only comes to 19.
1,800 square feet per floor. I mean, I just don't want the conversation to be, we're worried about a 400 square foot living space, right? So put it in context, we're talking about each floor is bigger than the average typical home anywhere else. I just want that context to be understood, that we're talking about whether it's 1,800 to 3,000 square feet per story.
And I can say that Naples currently uses the daylight plane, and I don't think most people would be concerned about those houses being too small generally.
Yeah, in a big grand scheme of it, when we're talking a 12, 13, 15,000 square foot house, 400 square feet is.
We're not talking about 400 square foot stories. That's the
that's
only
right.
point I
But I
wanted
mean,
to
just
make,
that
that it's
little
not.
bit of a elevator not even.
Right.
But the angle option would restrict your options as far as architecturally. Is that what I heard you say earlier?
We think without relief, right? Without some
Well,
kind of.
the reason that we included the relief on page, well, where did we put it? 57, yeah, where we allow 25% of the roof area to extend into that so that you're not lacking architectural features. You don't just have people building up to that line and then creating a straight roof.
So then the angle is measured from not the roof line, but from the actual, where, say, the roof truss would sit on the wall.
No, it'd be
Well,
the-
that's going to be wherever it comes.
Right, the angle, wherever they build to would be the roof line, and then there's projections, whether it's a window or some type of.
Would be
bay window or
allowed to
something,
go
Would be
past
allowed
that.
up to 25% of that surface area
Past that
would be
angle.
allowed to come past that area.
Okay.
Up to I think we said a maximum couple feet, if I'm not mistaken.
You know, so people can still have chimneys and towers and, you know, creative architecture.
That was the heads up by architects, was the flaw to some of the daylight angle is it makes it a solid roof if you don't allow for some of those projections. But again, we didn't want
We'd
to
be
get.
very, very specific in that because there are some people who get, like you say, very, very creative and
Sure.
all of a sudden find some way to circumvent what we are trying to accomplish here, which is to create a more open, they'll let us know that there's a beach over there, let us know there's water around us, to still maintain some character in our buildings and still, but at the same time, we have those who like to push our envelope, which we've seen,
Yes,
and
yes,
we even
here.
have some that are going up right now that are pushing our envelopes quite a bit.
And I think what we do is then set a maximum projection of that. So it would be 25% of the area up to a maximum of, say, 3 feet to be projected out or something like that. Whatever a normal window that you could get in for. But again, a lot of times we shouldn't be. Our red flag is windows in the roof line mean you're turning your attic into habitable space.
Yes.
So, but anyway, some of this is trying to solve all that so we don't have to guess what's in your attic.
Well, I still feel,
This is
I-
big.
Non-discussion.
Here it is.
Yes,
I,
and I think
um,
this is.
And we got
this is
lunch for you
altering-
today, so.
This is altering what we're doing here, and it's going to have a lasting effect on this island and the buildings that are coming our way. And not just today, but we have to think, if this is what they're doing today, it's going to get even bigger and more robust as we push forward. What character do we want on this island? What do we want this to look like? It's our job. So let's beat
And I
this
wa-
up.
I also wanna
Beat this up.
This doesn't, I guess, we don't zone ugly, I guess is kind of the phrase I usually use, but good design, that's got to come from the property owners ultimately. These are just the parameters and the framework of which we want to protect adjacent neighbors, a height issue. But at the end of the day, good design has to come from the architect and from the property owner. And they have to define what really good design is. We're not trying to define good design, we're just trying to make reasonable application of rules that create light, create space, air light effects that you talk about.
And still allow people to build something that they like and they want.
Question on mechanical equipment, because that has come quite a few questions on that as these houses are getting bigger, have 4 or 5 units, they spin up, they're loud. I mean, doesn't look like we made any real change to that to address the fact there's going to be sitting outside of people's bedrooms and things like that and such, to where they can put them.
Didn't address that in this section of code. I believe that is part of some research being done by one of the other planners.
So, yeah, one of the concerns is right now where.
Yeah.
So initially the additional setback or the eliminating the 5-foot setback essentially will help that. I think the only other way, it's hard to figure out a way to do that. Nobody's doing it. Nobody's got a real great successful look. Here's a code that works perfectly. Banking them all on the same side, I think, is one of the approaches that we could look at. But then again, we're really getting into, I think leery of getting into.
They're already banking them on one side, now you have 4 units outside of a,
Yes.
and they're loud.
But I'm also leery of getting into pre-designing for the MEP engineer.
Okay.
But
Yeah, especially if you have a really large structure, you know, if you put them all on the same side, how much additional piping do they have to install? I mean, how much more difficult
More
does it
concerned, is
make
there
it?
other places that we could be allowing through our code to place these items up on roofs and other areas?
And do them on roofs, it's just
Yeah.
expensive for maintenance.
Cost, yeah.
And how tall the buildings are, it's hard to get to.
And that is true.
Enclosed or, but again, I've heard that the ricochets, the noise that, exacerbates the issue, so we don't have a good answer
That
to
is
that.
being
We're looking at it,
addressed.
yes, we're trying.
Yeah, we are looking into that. We didn't cover that in today's topics. We felt like it was pretty wide swath as it was.
Well, I have I'm still, have you eliminated the distinction between waterfront lots and non-waterfront lots? Is that no longer in the code?
It only applies to accessory uses. It does not apply to primary structures. So primary structures are a flat setback.
When did that happen?
I do not know. It's been that way since I've been
Because
here.
that certainly wasn't what we originally drafted.
I don't know. It's
Okay.
been that way since I've been here.
But now, let's see, 34,638, describing two types of side setbacks, waterfront and non-waterfront. So that, apparently, that's how.
That applies, for our purposes, that applies to accessory structures only.
Doesn't say that, though, at least in my code.
I don't know. I'm sorry.
Okay. Well,
Could I just follow up on what Dan asked? Is it possible legally in order to reduce the burden from an enforcement standpoint on the vegetation carrot, if you just applied that to oceanfront properties, is that possible legally to do that? So you'd have less to deal with from an enforcement standpoint? And obviously, our view corridor issue is particularly poignant there. Is that possible?
Well, also, do you care if it's beach or do you care if it backs onto a canal? Do we really want to see through to, I mean, it's a waterfront lot still if it's on a canal, but do we want to look into a canal area? There's not much to see, so would you want to differentiate between that?
If it's possible, I think it would be wise just to do along the beach, but I don't know if that's
Bayfront and
legally,
beach.
or bayfront or beach.
Bayfront and beach,
Yeah.
because I think that's the other piece, is people like to enjoy that. As we had a case here 6 months ago about a bayfront property and side setbacks. Well, but in that case, you need to speak in there too. But in that case, the neighbors all came in and stated, we built the code and we built our houses around this idea that as long as he had to build the code, we all had view corridors of that bayfront. So I disagree. I think people are looking to the bayfront also for view corridors as well.
They
I
had
can't
a
remember
road
what
to
street
look
that was on
down.
with it had the boat ramp
That-
too as well.
That's the
Yeah.
street behind the hardware store, but that's because they had a road to look down for their view corridor. I don't necessarily think you should
not
be
always.
able to
they're not-
control
not-
the value of, but that case that we had,
Yeah, but
was.
again, you
Okay.
had residents who had built to code their houses up and down that street and built in a way so they could enjoy that view. So you can't say that they're not, that the view corridor doesn't apply also to the bayfront, because I do think people do.
It's a very big concern on the property that I referred to. It's on the bayfront, it's not at the end of a street. And it will seriously impact the vision from the people across the street to the bay. So, that's why, yeah.
but we have to also consider what rights they have to build and have some privacy.
Well, I mean, they could still build a
But
very
this is a
large
carrot.
house.
Yeah, it's a carrot dynamic
Yeah.
for the this is just for the vegetation piece I was talking about, and that would be a carrot for those that would really have an important view corridor, bay or ocean side, or beach side.
No one's saying they can't build a substantial and reasonably sized or overly reasonable sized house. It just, we are now still protecting everybody's rights here on the island too as well. It just can't be, we have to only allow them, it has to be we're a community and we have to look at everybody as a greater whole. And no one's saying they can't build a big house there. No one can't say they're build a monster house, as people like to explain them. It's just that here now we're protecting some of these other view pieces that we never imagined 20 years ago would be being built. And, somebody bought their house across the street from the bay with this idea that they could see the bay too. And their property values reflect the fact that it has a bay view too.
But they also had the right to buy the property that wouldn't be obstructed.
True.
So, I mean, you have to look at it from that side as well.
I mean,
I think what we're talking about is carrots to help preserve the view corridors.
Yeah.
So it's not imposing anything on anyone. It's saying, here's another option for you that gives you some additional height and some things you want, if you would be willing to preserve the view corridor. They don't have to do it. It's an option. That's why I like the carrot approach.
And I think that is the goal with the carrots and sticks, is that, you know, you do get something. You give something that the town wants, that neighbors want, and then you get something like an extra story or additional height.
I like the carrots and sticks idea, you know, quite honestly, because it's very distinct, it's very specific, it gives lots of options, just my opinion. But
Well, and as Jim said, it gives you some options. You give me this, you get that. It's pretty simple.
And you would still get, if you wanted
Well, I
to
mean,
build your
basically.
box
Yeah.
at the current heights, you still get the box at the current height.
But I guess back to Dan's point, though, the question is about these side setbacks, and I think that's for us to discuss here, too. Are they enough, not enough? Is there a better way to be doing this? Do we make the distinction between beach and bay versus everyone else? I mean, this is up for discussion.
Personally, I think that we look at it and we're trying to make things really complicated and all of this as far as dangle this carrot or this setback, that setback. Architects have a very good way of working around a lot of things, providing they're given some minor directions. When we when we look at what we're really trying to accomplish here, the first thing we were looking at was what's the view corridor, okay? We put it to our town come up and says, okay, we want to go from 7.5 feet out to 10 if it's above 55. Great, we now have extended out the distance between each house. But we still don't have a view corridor. There's nothing you're going to see because we don't have anything here saying, hey, you can't put any vegetation down here. We got to have a space with no vegetation, so as we walk down the street, I can look down between these two houses and I can see the water. We don't have that, so we haven't accomplished anything. When we look at this whole idea, and I really don't have any problems with porches and, you know, first floor and everything, but now we get into, we have side setbacks, we have a front setback, we have a rear setback. You have just defined what the definition or the footprint, as Jason has said, what the footprint of that house is going to be. How many floors are you going to make it? Meaning, do you want to see a roof line or do you want to see tree line? So we come back to the idea that, okay, FEMA says you're going to be X amount of feet above for your first floor. Now, that's only a recommendation. If you don't want to go, and I'll use it 18 feet as an example. If you don't want to go 18 feet up, put your first floor, put it 16. That allows your first living space to have a 10-foot ceiling as opposed to an 8-foot ceiling. If you want 10 foot on the third floor where your bedrooms are, put it at 14 feet. Your options. But what we're looking at, and we're talking about, we want to have view corridors, we want to have a heights limitation of total housing. Make a determination of what the total height of your house wants to be, what we would like it to be, to prevent us from having these monster houses. All we have to do is say, 3 floors, standard size roof, here's the height. Now, we leave it up to the architect to design the house to fit within inside that cube. Now, a lot of these architects, they're out there vying for business, so their imagination on how to build or what to build to accomplish what the client would like is going to be very easy. But I think if we get into this, and here again, prime example, yes, we've got the great setbacks for the side, but how can we enforce the view corridor? You can't. Not unless you have something in writing saying no vegetation, no fences, no mechanicals. You got to have a view corridor if that's what you want. The same thing goes with your height. How are you going to verify that this roof line is that angle. It's going to be a nightmare. If you want to have a sunlight corridor, then just say, okay, your third floor is going to be, oh, I don't know, 25% less than what your first floor is. It's going to be built in a little bit. Make it something standard, something easy that these people can understand, something easy that we can enforce. But if we get in here with a whole conglomerate of this, or you could do this, or this, and this, how are we going to verify it's ever being done? This is what I don't understand. We're getting down in the weeds and trying to make something complicated. The architect wants a cube front, back, height to build in. End of story.
Well, that's what we have now, and that is what people understand, is that here are our setbacks and here's the box size. What they're trying to do is create so that they all don't look like boxes, but in doing so, they aren't really getting what they're asking for in view of corridor, because you can have a 6-foot-high fence that goes across the sides of your property, and then, you know, by having it go in and in and in on the third floor, who's up there on the third floor that can see across the corridor? But, you know, it's not a drive-by view.
No, and that's what I'm saying. As
Well,
far as
I think the other piece is,
there's no drive-by view with these setbacks that we're determining right now.
In a light plane, I think
That's
I
the
think
other
what we're
piece.
trying to do is get rid of the canyon effect that you have on Bonita Beach Road and even some of those houses over here on Estero. I think the goal is to have that light plane. Yeah, sure, you're not going to be able to see the ocean from the ground view, but you're going to have more light. And what was also brought up was this is not going to stop at the beach. It's going to go to the beach, then it's going to go to the back bay, and then every street's gonna have these monster houses. I mean, there's one going up on Palmetto. There's one going up on Randy Lane. They're starting to build in interior streets now, and if we don't do something, it's going to be one big box canyon. So,
Well, this is what I'm saying, is if you don't have that view corridor for the pedestrian, and it's any view, whether it's a waterfront lot or not, it's still, we have to have something that says between each of these tall buildings, we have to have some way of viewing in between. We don't have that right now. We're giving us the dimension as far as giving us the space.
I disagree. I think that these two plans here in particular do create more space, more light between these buildings, and are looking to move people in a little bit as they go up. Again, it's more about keeping light moving through this island as well. You know, just because I can't see the water when I'm driving by there, I do know that there's a lot of light coming through there, and it is a more, you feel like you're on an island, not in a downtown district. If we, you know, the way we're building right now, within this close and these big boxes, you know, it's going to feel like you're just driving down a city street in some ways, because there's not light coming through. And both of these plans, if you look at them, do start to address that effect too. And this is also, like we said, going to go down the side streets, where our pools aren't going to have sunlight on them because the house behind us is built, you know, and the house next to us and the house next to them. And so we're going to be limiting even sunlight on our pools and everything else that we do, unless we do. So I do think that both of these address that. The question is which ones address it to a point that we feel that is best for this committee
And if I could,
for our island.
and there is somewhat of an in-between, if Sarah could walk through some of the other provisions that we're not talking about in the carrot stick that can be carried over.
Okay.
Yeah, I mean, we could have some variations in the light plane based on if you leave, one of the issues that we have is leaving that lower level open. You know, especially on the beach side, you know, you've talked about vegetation on the sides. If that lower level is open, a lot of times you do get kind of a little bit of light coming through, and it does feel more like you can see the ocean from there. Not great, but to some extent. So we can use we can use some flexibility that's in the carrot and stick method and apply that to the light angle method. If you like the light angle, you know, say it's this angle, or you get a 5% reduction if you provide this or provide that.
I think the first floor option is a great one, because if you come out of Publix, just a simple example, you can see the ocean underneath that complex right across from Publix, and it's great. I mean, we all get used to it because we live here, but I think for people visiting, that's a really nice, quite honestly, for people who live here, that's a nice option to occasionally see the water. And
It's a very nice option, but if you're talking realistic, most people want a two-car garage. Most people want to put all their crap in the garage so they don't become missiles and have to pull everything in when they go out of town. And the other problem is if they get permitted to build the building because they leave it open, the next homeowner is going to have a handicap issue that has to be enclosed because they have to have this, and or they'll find some reason that they're being burdened by not being able to enclose their downstairs, and they'll get it enclosed and still get all the benefit.
Can we address that, though?
Yeah, I mean, we've looked into agreements to not enclose, and you can record that on the property, and when they buy the property, that is a component of that property, that as it exists, nothing can be done. And we're not talking about not enclosing anything. It would be 300 square feet, which is a substantial space.
And there's some flexibility between that number. I mean, again, I think when we're talking about 1,500 to 3,000 square foot of area per floor, to your point, Jane, is two-car garage, storage. Can you fit that in 50% of a typical first floor? Probably. We're dealing with 2,000 square feet of storage right now that are being labeled and broken up illegally sometimes. So yeah, no, imagine that. So whether it's 50%, whether it's 300 square feet, I think there's a range of options that we could offer. And that is, in the future, one of the things we're looking at doing as we go through the CRS evaluation process and our points. Agreements to not enclose. We get a lot of points for having those be a mandatory thing that people sign. Access to make sure that we can enforce those, but also as the square footage part of it, we can apply that. We're going to be looking at bringing that back for you. So this is kind of ties into some of that and sets up the table for us to be able to implement some of that stuff.
Well, the only problem with that is on the 50-foot lots, there's still going to be a major issue of reducing. You're down to one car on a 50-foot lot because you only have 35 feet. If you take,
But I think we're talking about carrots, right? So we're not saying as a mandatory. It's if you want to gain some mass back.
Stories.
but it also
then-
concerns me that you're just deleting the issue that we do have on this island of non-conforming legal lots of record that are not 55 or 50 feet, and you're giving them all the same setbacks, and like their box is going to be 20 foot wide.
They're not conforming because we assigned a zoning district that says so, not because the lot width itself. So Sarah was talking about, you can have a 50-foot lot in one zoning district that's non-conforming and another district that's conforming, and all of a sudden
I thought you were going to bring them all together, and here's the lot sizes.
Right, so right now, we're trying to cure that issue, which is because you happen to be a 60-foot lot in a zoning district that has a minimum of 75 today, all of a sudden you get a smaller setback potentially, right? So 50-foot lot can have a 7.5 foot setback.
I
Just treat
understand
them all the same.
that, but the ones that are under that or that have odd sizes, we've, always given, pick your sides of which is your front and your back and this, that, and the other.
And we still do that, and there's still administrative variance relief, and there's still public hearing relief, variance relief. There's still all these other components and processes that can relieve that. I don't think a 50-foot lot, in my personal opinion, a 50-foot lot should ever be considered non-conforming and get a substantially reduced setback, because a 50-foot lot is the typical lot
I'm
they're
not
putting
having,
anywhere else.
I agree with you.
Right, 45, 40, I mean,
That's what I'm saying in here is that you say if they're whatever, now they're a lot of record, whether, if they're legal, they're legal.
but again, some of the point is, some communities, and here we have some of these where you have, I think I used the example last time we talked, you have downtown areas that have 25-foot platted lots. Well, at some point, you got to stop giving relief to the setback and just say, you need to own multiple lots to build on a property. So at this point, once you get below that 45, 40, 35, are we going to keep going with 10%? I don't think that's what
Then
the
you have
intent was.
properties that are not being repaired or whatever because they can't afford to tear it down because they can't afford to rebuild. I don't think that's a good answer to the problem
But
either.
they can always request a variance, and that's what most people do if they don't feel that they can meet it, and then they provide evidence.
We fight so much with people over interpretations of conforming and non-conforming. I don't want to do that anymore, frankly. Sorry, John, not ambiguous, but it's all because somebody colored it a certain district in a zoning map, all because the majority of that area was RS, so we assigned it these certain minimum lot sizes. Well, now we just made a bunch non-conforming. Now, all of a sudden, we're giving relief to those. And now we're interpreting whether the timing of the plat versus the zoning district and the incorporation of the town. We just want to be as simple as possible and hopefully achieve what we were given direction to achieve in the beginning, partly anyways.
Not having undue impact on the neighbor. I mean, the neighbor owns a house, they have a 7.5 foot back, 7.5 foot setback, but they're being affected by their neighbor who has a smaller lot. So their neighbor can be 5 feet from them, but they were required to be 7.5 feet. So they're being impacted by their neighbor buying a smaller lot, or maybe not buying 2 lots.
I hate this.
That's why we brought the difficult stuff to you guys.
Let's send it on to town council and let them.
Well, we need you
I
to
think
pick
it's
some
our job to beat
options.
this up and get it as best we can before it goes to them.
That is.
You know, something that, as a
Well,
7 resident member board representing different, interests and however you want to put it here on this island can come to something here that we feel is a great product before we send it on to them.
Just in the interest of expediency, I support the carrot and sticks method and encourage staff to further develop a vegetation policy with an additional carrot for that prospective home builder.
And carrot stick means the way it's outlined and kind of basically what we presented was here presented at the joint meeting method, right?
I can't remember what the exact
Yeah,
carrot was for
tiering
the
in and doing, if you do this, then you get that kind of.
Right,
Okay.
but I also like some kind of a
what's in here.
vegetation provision that makes sense to be enforceable. And whether that has to be, in order, from an enforcement standpoint, if that has to be restricted to both the beach and the bay, just to limit the amount of enforcement in that particular venue, I think that might be helpful too. But I really like the carrot and stick option, that again, people can do what they want to do, but if you incent them to do the behavior that the town sees as its public interest, that seems like a nice way to do it.
I'm not sure if we do a motion on this or if this is just recommendations to you guys. I mean, it technically says a public hearing on this
I think,
and recommend approval.
I know
but-
we made it difficult by giving you 2 options in each, but
Yeah,
I
and you
think
gave
some
us 2
consensus, I mean, it sounds like, Kim, right, Johnny, consensus on each of the issues, if you can get a majority consensus for each task.
We
and
could
then
take a
put it-
quick poll.
Well, we need direction from you all so we can actually, an
Okay.
ordinance format that then, in accordance with the state law and the town code, will come back to you all for a vote to then forward on to the council with that as your recommendation that the town council consider at first and second reading and ultimate adoption as a new section of the land development code that will replace the section that we're revising.
So it's not as much a motion and it's more of a direction for you to go back again.
But here,
So I think
the reality is if it was, yeah, we love the language, the way it's strike out and underline, move forward.
well, we can't,
we
you
go
gave
do
us
it.
2
But
options. We can't.
But we gave you strike out and underline related to one option in each of the 2 choices. So if you like the other option, we have to go back and tweak some of that. Correct.
Madam Chairman, I would like the staff to consider the possibility of a percentage. For example, I'm talking about side yard setback now. 10% of the width of the lot, but not less than your 7.5 and 10 feet.
Is a setback
Just-
rule or is an exemption or caveat
But
to?
because then you get more.
In considering the proposed ordinance.
Okay, so
Yes.
More setback.
So what that would result in, for instance, along Estero Boulevard, that would keep, the larger homes along the beach. That would keep the setbacks the same. That would be 7.5 feet because those are 75-foot wide lots.
Are they all? Is that the average?
That's the average.
Okay. Well,
And that's one of the main reasons why we proposed a difference is because we're already
Yeah.
seeing 7.5. And if you're saying in a lot of instances that's not enough, our lots aren't really huge, so
well,
you're not seeing a difference.
there's a lot of lots and side streets that are bigger than that. So,
What if we did over a certain square footage, then these would apply, so that you don't get the monster houses, but the smaller houses can be built and still have reasonable square footage? Like 3,000 square foot or more has to do this and this,
Lot
then.
or home size?
Home size. I mean, that seems to be people's problem, is the mega houses.
So I think,
What I'm concerned
I think
about is
my
the small
concern is
lots
certainty.
can't build houses.
my concern is then you require somebody to do a design to figure it out. I can't buy a lot knowing what the standards are. I mean, I get what you're going. I've heard some of that before in other places, and my concern is the certainty part of it. If you buy that lot, you don't know what your setback and what your tier is going to be until you design something, and then come bring it in and say, is this my setback?
And that is the biggest question that we get when people, real estate agents or, anybody looking at property, they call us and they say,
What is my setback?
what are the setbacks?
Well, that's
And
why
I
it's
can
simple,
give them
because
that.
they are what they are, and as a Realtor, I've always been able to say, here are your setbacks, then you can only build your box in between.
I think the other piece here too is if we went with these numbers, just go with them because they are a number. And these can be adjusted at another later date. If we don't feel that this is
Clearly already have been, apparently, from
appropriate
some other codes.
to what's happening, but if we sit here and debate is to this T, we're gonna be here all day debating what the appropriate number is. And quite honestly, until application, we don't know what that number is. We know it's not what it is today, so let's increase them by something and see if we get the desired effect.
Could you do it just by the lot? So if you have your single lot, like James talking about, that's 7.5 feet. If you choose to buy 2 lots, like on Randy Lane, it goes from 7.5 to 10.
Right.
To keep it simple.
Yes, that would occur, that
Well,
could occur.
I would have to say, though, that in some neighborhoods, the lots are much smaller. So you have a 45-foot wide lot, and the lots are different sizes. And if you buy multiple lots, that may not accurately reflect how large the lots are.
But then
So-
couldn't you put into place if it's greater than this, you get this, if it's less than that, you get that?
And that's what we were trying to do.
And I think
seems
to your
pretty simple
point,
to me.
yeah, to your point, if you had 2 45-foot lots, one of them is a 7.5-foot side yard setback. You put them together and build on it, it's essentially a 10-foot side yard setback if you built over both of them, because you went over the
Right.
55-foot threshold under what we proposed.
Right.
So that's how that would work out. That bigger home and the
Seems-
bigger double lot would have
Seems
an
simple to me.
increased setback.
I
Easy
mean, like I
to
said, we
figure
could
out.
sit
Right,
here.
and if for some reason that home was torn down and those 2 lots went back to individual lots, then
Then you
they
go
would
back
have
to
the
the
7.5, right,
Yeah,
it
so it
depends
would
on
be
what you build
based
on.
on lot width still?
Remember, we
Yeah,
still have
essentially.
we still
Okay.
have the appropriateness that if something is, or someone disagrees with what we're doing, can come and ask for a variance from us too, and can state their case as to why they want one, what's the purpose of it. They do it all the time here, so I don't see, I think we pick a number, we go with said number and see if we get the desired effect.
But I think to Dan's point, at both Dan's, I think, under your scenario, I think what we were talking about is the difference would be the 10 would be the max versus a percentage. So if they did 45 and 45, that's 90, then it would be a 9-foot side yard setback versus the just trigger to the 10.
Yeah, I mean, for me, I think
It kind of results in the same, but
the more simple you keep it, the less you have to deal with the conforming, non-conforming, all that back and forth, and the variances and the deviations and the,
Yeah, and we definitely want to get rid of the non-conforming
Yeah.
portion, because if you buy a small lot, you still have the same setback, because you're affecting your neighbors the same amount. At least that would be my view.
well, then everyone has a clear vision if they go in to buy a property, what exactly they're gonna have. There's not I've gotta go calculations, and it seems like it's too complicated. And for the record, and with Jim, I like the sticks and carrot option.
So, I just want to kind of get an idea, like plain sticks or carrot? Is your thought, because they're looking for direction from us too as well.
Well, I think that we need to increase, and I'm more concerned about the ground level than I am in the angles, but I think that's something also to consider. But I like
They're to walk out here and start working on ordinance, would you prefer them to write it off the sticks and carrots or off of the light plane after reading both of these? We can address the side setbacks.
that alternative again.
The light plane
Oh, okay.
or the sticks and carrots?
I like the light plane.
Okay.
Here we go.
Scott?
Right where I thought.
I've been light plane from day one.
So how about, oh, sorry, go ahead.
Okay.
If you had it to us, you're on.
You don't get a no. Is it, they're looking for direction from us. I know that you would like it to stay the same, but if it, which of these two options would you
Jan,
prefer?
would you light plane with some stick and carrot component to it related to the bottom floor?
And carrot, you also can get what you already have. You can just also get some other things if you choose to give more.
I don't think that some of the components are real to be enforced. I mean, I don't think that ground level thing, if you give up the space.
Microphone. Before she comes out of her seat
There will be
again.
people with exceptions. So, yeah, a combination thereof, but, and I have an issue with the smaller lots still not, and the odd-shaped lots really not fitting in here workable.
Well, but the odd shape, every odd-shaped lot ends up in front of us for some various reason. Every odd-shaped lot ends up in front of us. So, I mean, that doesn't,
Not necessarily,
not, you're really not going to be able to address that,
till we find out later that they're built.
so.
3-3, what do you say?
I am of the stick and carrot. I feel like it's an easier, it's very predictable, opens options up. You know, here's your, you want to come in 5 feet, you get an additional story type situation where it's a more of a mathematical equation and less of a, but they still have options to add architectural features in there as well. So on that one, I think, you know, we're kind of directing them towards sticks and carrots, and I'm sure they're going to come back to us with more improvements on it. Now, on the side setbacks, which Dan has brought up issues, some people have brought up issue, I think that maybe that one is not so clear as to what direction to go with the side setback piece of this. Because, Dan, you feel like it's not enough. Am I correct on that, especially on the waterfront pieces?
Well, yes, I guess that would be a
Correct.
fair statement, not enough.
Okay.
Well, and I think
There-
oh, sorry.
Go ahead.
And I would also, apparently there, we've lost the distinction between waterfront and non-waterfront, and I would, on the primary building and not just the accessory building, but I think that should be in the code. I think there should be a distinction.
Which really wouldn't create a conforming issue if it's waterfront versus non-waterfront.
Well, I do want to point out on the accessory, it doesn't, if you're non-waterfront, you have a 5-foot setback for accessory structures. If you're on waterfront, you have a 7.5-foot setback. And the house, the primary structure is 7.5, no matter what, water or not water. So I think it was moved in a more restrictive.
That wasn't
That
what the
doesn't
original
sound-
code
That's not
was,
true.
so that's been changed somehow.
I'm sorry?
Yeah.
It's larger on water, side setbacks,
For the primary structure.
for the primary structure. 20 feet at least, if
I'm not talking
25.
about from the water, we're talking about side setbacks.
Yeah,
I'm talking about side
you're referring to the water body setback, I'm talking the waterfront setback, they're two different
Okay.
things, okay? The water body setback is 25
25,
feet.
yes.
Yeah. The water side,
Side setbacks on a water.
waterfront side yard, in my code is 7 feet, except on waterfront, 10 feet. And so that's apparently been changed over the years, and there's no longer, number one, a distinction, but number two, that they different in the figure.
We would be moving more in that direction. Would other members be in favor of having a 10-foot waterfront setback, not doing just the
Side
difference in the side setback, I apologize. Not just talking about the width of the lot, if it's more than 55 feet, doing a 10-foot setback, but saying if it's on waterfront, it's a 10-foot setback.
I'd defer that.
Yes.
Yes?
I think this will create many more phone calls to the town hall to figure out
A lot of
what
phone
they can
calls.
build. But I mean,
We already do.
before, you could say, here are your setbacks, build your box. Now, you can't do that at all.
You gotta stop telling people to build a box, that's what we don't want.
Well, but, you know, we can't,
I'm kinda teasing, but at the same time, we're
make it
trying
legal.
not to build boxes anymore.
I understand that, but you also got to have some way to be able to say what's here.
And you can.
But I also think
Your
that it's
first
always a
floor is
good
X.
idea to contact staff because real estate agents don't always know. There could be different things associated with that property. So it's always a good idea to contact the town hall before you say, I know what I'm going to buy, I know what I'm going to build, let's put it in, call the town.
Time
We'll
out
tell
here.
you.
They can still build a box. The box is just coming in a little bit, and it just can't be as tall, but they can still build a box. So I disagree that you can't say, this is what you can build on this lot. Now, this is what you can build, but if you want to go bigger, this is what you have to do. But the base settings are still X. They're not a moving target. You can still build a square box.
No, you can't.
Yes, you can. Yes, you can.
You don't get the additional height allowance, and you don't get the additional story allowance, but you can still build a box.
Still
That's
build a
just
box.
with the carrots, the sticks and carrots, right?
Technically, with anything, you can build a plain box. It's just your choice of
I know.
the footprint,
Okay.
so.
Yeah, I
Dan
agree
Hughes
that,
is leaving at 12 o'clock.
Okay.
Sorry,
am
for
I
the record.
taking him? Dan, do you have a ride? Yep. Okay.
Okay. But at the end of the day, you can still build the box. And it could still, you as a realtor can say, here's what you can build. Now, but if you really want to build something, here's the calculations. Let's not forget, you can still build the box.
Still going to have, the 40% coverage for a building. And, if you're not in a residential zoning district, then you have the percentage coverage. So those things won't change.
Do we want to go down the road of if someone has the option or has the ability to buy a bayfront property or a beachfront property, that they should have a different, if their lot's 75 feet and mine not on water 75 feet, I can technically go further on the setback than they can? Do we really want to do that? I don't think that's fair. If someone has the right to buy or has the means to buy a property on the water, why should they be penalized if their lot is the same size as someone that chose or only can buy on a non-waterfront property?
Make them all 10.
Or they do know that going in before they purchase what their options are, so they have to make a determination as a,
Yeah, nobody's making.
Sure, you're still gonna sell houses, Jane, I promise you.
They're still
Still
gonna
sell,
be big dollar houses.
still
It's
sell
not about
houses
real
like
estate,
crazy.
it's about what rights are and what people have purchased with the understanding of what they can do. And you have a house that's pre-existing and you tear it down and all of a sudden you're now at this, where you had this. We're not going to have houses come up to standards because they're going to lose 10 feet.
But
I definitely think that all of the houses that are on the block for demo are much smaller than what they could build today. The
what they
majority
could
of the
build.
houses that are at that phase in their life are much smaller than what we're seeing today. And that wouldn't be affected a great deal.
I just think that 7.5 is a standard in most places. If you're going to take more of their property, then you should give them the carrots. They should be able to build to their setbacks unless they want to do something unique or different. Then, you're not taking a right of theirs away that they purchased and understood when they purchased.
What if they choose to purchase two properties side by side?
Then they still have a new setback, 7.5 and 7.5.
You wouldn't think it'd be okay to bring them in since the house is going to be essentially twice the size?
Not really going to be twice the size.
Not necessarily, but, I mean, I think if you buy two properties, I don't think to give up an extra 2.5 feet on each side is
Room.
all I like, because as the house gets bigger, the more
a
air conditioners
bathroom, a
you need, the more
laundry
pool
room,
equipment you need, the more, everything you need, that's going to fill in that side setback, unless they choose to put it on the roof.
I'm just saying that I think that I think going across the board and taking 10 feet on a 50-foot lot is tremendous.
Well, I'm in agreement with you. I think it's 7 to 7.5, I'm okay with, but I think if you go to two lots, then maybe you consider 10 is the standard. If you go
That's
to
what it's,
3,
but isn't that what that's what they're suggesting right now, is it on 50 foot unless it's 7.5 feet?
55 or less.
Above that is 10 feet. I mean, it pretty
pretty simple.
simple and does that, exactly that.
So where do the members stand on that issue?
We're going to prepare the carrot stick, work on
Yes.
fine tuning those carrots and sticks. We're going to stick with the setback change unless, I mean, we honestly talked about greater because I hear everybody saying that, and then yet everybody clamps up a little bit when we actually talk about greater. So 7.5, 10 seems to be, make you nervous enough. We'll see how that goes. We can always go more later on.
Again, put it into practice. If it needs to be altered, then it can be altered.
So we'll
That's
bring
the
that back. I guess it
purpose of
sounds
us.
like we need to fine tune and bring it back to
Okay.
you as a complete revision to that, but fine tuning some of that.
Would our motion be to send it back to you for revisions?
We want answers on everything first. What
Okay.
about the porch? Where do you guys stand on the porch? Do you want to allow the porch 10 feet into that front setback? Do you want to completely take that away? Do you want to just allow it on that first livable level?
I don't know about porches, but I do like, the stoops and to effectively get what you want out of it. I think when we say porches, there's a large definition of porches, and can a rooftop deck go on top of a porch? And
So do we need to define porch more clearly?
yes,
So part
Stoop
of the,
isn't defined well either.
right, so again, remember, size of this matters, right? The scale of everything. So part of the issue that, Sarah had mentioned before about the 2-story, making sure that it's only for the entryway, you're still going to get 14, 15 feet of height in these because of flood. So that's kind of why we've been pushing towards that. I don't want to say pushing, but moving towards that of the 2-story shouldn't definitely not be allowed. And I don't think that was ever the intent, to encroach 10 feet into the setback.
Yeah, based on the reading, we don't think that that was the intent, but the way it's written, technically, you can get the 2
question for you
stories.
guys. Are you
Yes.
familiar with the house that's going up across from 7-Eleven right now? The big round front house? I don't know.
7-Eleven.
The 7-Eleven down here. Sorry, I forgot there's 5 7-Elevens.
Sorry, we do
Yeah.
so many, it's hard to.
I know, but right down here,
By the gym,
drift-
by
yeah,
junk
by the
mail?
gym.
Okay.
Has that nice round front that protrudes way in. Is that, I mean, we're
Do you mean on a stero or do you mean
on
on?
a stero. It's on
Okay.
a stero. And it is
On the golf side?
golf side, right there. I mean, it's
I
a
believe
monster.
I
going
believe
up.
it's Hardin.
Yeah. Now, that big round front, that is considered living space and that shouldn't be protruding into or is this another case of where we need to, as we're looking at the definitions of that, because that's coming way into the setback.
Remembering the design of that, I believe that actually does meet the 25-foot setback.
Okay.
And I think that that's one we've gotten numerous calls on, and we've required them to submit their foundation survey.
Okay, because I
So-
was
I
just
think
wondering
that
if,
one appearance might be a
because
little bit.
appearances, that kind of
Yeah.
looks like it could eventually be a porch or something because there's no walls on it. And I'm just trying to figure out how that fits into this.
That actually does meet the setbacks technically, but that's an instance of where that's going to be a massive structure because of the flood height. So it being 25 feet away, even 25 feet seems very close.
Oh, yeah, it feels like it's right up on top of the street with that protruding round front to it. Oh, okay.
So
I
you're-
just-
So encroachment is okay if it's, as long as we narrowly define, is that what I'm hearing? And limiting what it can be for these porches and stoops?
Yes.
Okay. Not eliminating them altogether.
Yeah, but, the bigger question is who really uses it? The porch is mostly on these, it's not on these big monster, well, I guess it kind of could be on these big monster concrete buildings.
Yeah.
We
But they're
do
more
see,
on
we
the-
do see them on the smaller ones
Yeah,
and on
and
the
that's-
larger ones, not as much on the really giant ones on Estero Boulevard.
Yeah.
They tend to not care as much about having space that
Theirs on
close
the
to
back.
Estero Boulevard. Theirs are on the back, that's correct. But along the side streets, we do see a lot of the 2-story and the single-story. But, it's all about the appearance and how you want to limit that.
And let's be honest, the reason why that's there is it also allows you to increase your buildable square footage up to that. So it's almost like a exception to the box, right? So
The other question is, do we eliminate the encroachment and they just have to build that within their setbacks, period?
Correct.
It's a question for everybody here. What do we feel about that? That now needs to be moved, not necessarily into the 10, be able to encroach on the sides, on the front setback by 10 feet? Should it be within their setback period?
Always has been within their setback period. When did this?
They can encroach 10
They
feet.
can encroach up to 10 feet on their front setback with a porch or stoop, and these are turning into the two-story porches.
Is
And
that,
into two-story buildings. That's,
But the
I
point
can
is,
get
in
with
either
you.
way, you're not talking about ground level porches. You're not talking about an inland community wants a nice, porch, front
Community.
porch community where
Yeah.
everybody's sitting down and chatting with
There's
each
no
other,
front
right?
porch
These are
community.
15 feet, 14 feet, 12 feet high, so it's
So should,
add on top of that potential what they're trying to push the envelope of. But it is a 14-foot, 12-foot structure that is encroaching into the right of way, or not right of way, excuse me, the front setback right now. So as the flood elevations go up, those become bigger. And yes, over time, we need to, at a minimum, nail down the language. But that's why we're offering you the option of, if they become overbearing with the appearance, as you've already stated, one that apparently meets the setbacks and still has the appearance of overwhelming the street front, do you need to have them?
that
Do you need to
question is,
allow the encroachment?
we can also reduce that encroachment to
Correct.
5 feet. I mean, that's from 10.
I have a question.
Mhm.
This 10-foot encroachment, that was basically in place for pretty much forever.
So it's been in place. My research on it is it's been a methodology that's been used more often in the
And
last few years.
All of a sudden, things change as far as with FEMA, as far as your ground level and moving things up.
Sure.
And this has never changed with it. So what we're
Correct.
looking
Yeah.
at is trying to come up with something that coincides with the newer regulations as far as height-wise.
Well, the intention of the porch in the beginning was to create a front porch community. But now we no longer build on the ground level. You don't have that ability because now they are 14 feet in the air and you're screaming up to your neighbor. You might be able to scream across, but you're not walking over with a bottle of wine and sitting on the front porch with them because their porch is 14 feet. You have to go through the house and back up. So it does no longer apply, the front porch community apply here, which was the purpose of that at one point.
I'm in favor of allowing them to keep the porch, whatever we come up with as far as how far they can go, 8 feet, 10 feet, whatever, but not going 2 stories, the single story. I think that would, it adds architectural character if you do put one up. If they decide to go up to a second or third story, it gives them a little bit of options, but yet you still keep that front porch mentality that the chair was just talking about. So I'm in favor of it. I don't think forcing them to keep it within their setbacks makes sense to me.
So looking at the staff report, you'd be in favor of option 1 potentially, allowing a single-story porch to encroach 10 feet potentially into that setback.
Yes.
Okay.
And if we decide 10 foot's the number, 8 foot, whatever, but yes, option 1 is the one I would be in favor of.
I'm comfortable with that as well.
Okay.
With that. I
Yes,
didn't
I'm
ever
okay.
think it was that, I never thought it was available, so I'm kind of dumbfounded. I always felt like it had to be
It's
inside.
become over-available, so.
Tim, what is your? Okay.
Okay.
Got your direction. We're good with it. Mhm. What else you need from us?
That may be everything. So we can work on some more specific language and come back to you. Do you want us to come back to you with specific language and then we'll move forward to council from there?
Yes, I believe that we'll probably have some more questions and such of that sort, and let's get this nailed down as best we can before we take it to them.
Sounds good. Thank
So
you.
I guess we have the motion to send it back for revision.
Consistent with the conversation that's taking place here today.
Okay, so do I
I'll
hear?
move to send the text amendments to the LDC 343274, minimum use determination back.
No. We aren't on MUD. We're on recommend approval proposed
I
edits.
just started reading, sorry. I
LDC.
recommend to send it back for edits based on the conversation for the Land Development Code, Section 34631 commas 34638, Table 34-4, and Figure 34-1-A, to be revised and brought back to us at a
You had, and other,
date
and other sections as may be needed related to the conversation.
Okay, at a date certain?
No,
Or, no.
Just, just other sections.
And
than-
other sections
That may be
that
needed.
may need to be revised based on the discussion.
Thank you.
I hear a second.
I'll second that.
All in favor, say aye.
Aye.
Passes 6-0. All right, it's back in your court.
Hey,
Thanks.
do we want to move on to MUD?
Do we want to move on to MUD?
I'm hoping that one's easier because
Okay, so let's try and get MUD in real
Maybe
quick.
not.
Actually, can we take a 5-minute break?
Yes.
We're going to adjourn for 5 minutes.
Okay.
Is that what?
No, that's
No,
fine. We're good.
Okay.
Tell me. Yeah.
Because we still have, we have mud, we have special event, and then we'll go do,
That's what I
we'll do
did.
mud,
Nobody told
break
me
for
that. I
lunch,
just
special
did.
events, and places of worship. Cool.
Oh, aren't you fun? I'm
See,
telling you
but we won't do the
what.
same for your meetings.
Can you go pick up my Jeep? It's up by the airport.
Oh,
All right, 12:22, and I'm calling the meeting back to order. And we're going to open the public hearing for text amendment LDC Section 34-3274, minimum use determination regulations.
Morning, Sarah Probst with Community Development.
It's afternoon.
Good afternoon. We've transitioned. So this discussion is regarding the minimum use determination, which is required for lots that are less than 4,000 square feet or don't meet our current, that are not conforming to our current future land use map density. So the way we're proposing to alter this section of code is to allow any lot that is a platted lot and has access to utilities and the right-of-way, direct access to utilities and an improved right-of-way would be considered a buildable lot. Currently, there are some instances that are, the lot's just under 4,000 square feet, or in some instances, there are houses that are on lots that are very small, 2,500 square feet, and the way this code is currently written, we're not sure that it says those are buildable lots. So what we would propose is ensuring that all of those lots that were subdivided lots are buildable.
okay.
Okay, any questions for the town, which is also the applicant? So, starting at the top.
And again, obviously, there's development standards that apply to these lots, depending, obviously, what we do with the other stuff and setbacks, but it may not, I guess we don't really have that many smaller than 40, but if there happens to be some 25-foot platted lots, again, those are generally commercial platted lots. Those wouldn't be a buildable house, obviously.
There are some
Commercial to start
very,
with.
there are some very small lots that were subdivided, that were single lots that were subdivided in 6, things like that on the northern end of the island, on the beach side especially. That's where I found the most of them.
Also down by
and-
Dakota.
Yeah, and so there are some very, very small lots, but most of them are already built. They have homes existing on them. The issue now is people would like to buy them, potentially rebuild on them, and we can't give them a good answer as to whether that's truly a buildable lot based on our current code.
They currently have a house on them,
They-
and it's currently built on.
Yes.
And if this answers that question, I'm 100% for it.
Shocked.
Let's wait for the public input.
More homes.
I think people should be able to rebuild if they have a house there. And you can't do that with some of the standards that are here. I mean,
I know,
that's what I was fighting for
I
from the beginning.
understand that.
This was our carrot to you, Jane.
Thank you, darling. You're so good to me.
After
Thank
putting you through the other one, yes.
You're so sweet. Thanks. I'd like to make a motion, but no.
Any other?
Anybody, discussion?
Discussion first, guys. Any discussion, any questions? Dan?
No, I mean, I'm all for making it simpler and easier to understand.
Jim? Jane, we know.
I've got questions. Are there any double lots that where one of the lots is way bigger than the other lot, or?
All of them that we found are pretty standard in size. They're pretty much a large section of land that was subdivided in the same size lots. And in some instances, somebody bought 2 of them, put a house in the middle of them. Now those lots aren't quite big enough, or they don't meet the density, and now they can't build on both lots individually. So they're essentially combined for good, even if they don't really want a giant house in the middle of both lots.
This won't affect any of that.
It would allow people to divide those lots. So if they had put a house between 2 lots, the way the code is currently written, if there was a house on it that crossed the line, they can't separate them back out if they're non-conforming in any way to density or to size.
They had to be platted originally to be built on.
Yep.
So you just can't take your own personal property, it might be large enough, split it into 2 and build. because it wasn't platted that way.
If it's large enough,
Yes.
you know, if it meets all the subdivision requirements, you can still do that. It's just most of these instances, they're already subdivided out, they're already existing lots, they've just been combined one way or another, and now they can't do anything with them as separate lots.
This also clears up what was taken away earlier in life here as a town, where they took any house that commingles two lots is now commingled permanently and cannot be separated. And it's been done 100 times since this was put out there, but now this will clear it up and make those all legal. And I won't fight it on every one that comes in front of us, because it's on the books. So this will clear all that up. All those houses on Palermo Circle will be okay.
Right, just for the record, I'll make sure it's clear that there are platted lots that don't meet the criteria that's outlined, because we talked about improved road frontage, utilities.
Right.
That cannot be built and won't get a permit.
Right.
Or they may, I mean, they have other issues with them, generally speaking, like wetlands and other things, but I just want to make sure that that's clear if anybody's listening to that.
That's clear as mud.
There are some that you may see and they're excluded.
There's a comment.
There it is.
Okay, so, Tim? Scott?
None.
All right. Open it, well, I guess it's a public hearing, I have to open it for public comment.
Not
No
gonna get
public
it.
comment, I'm closing public comment. Okay. Somebody like to make a motion?
I'll make a motion to recommend approval to the town council of the text amendment for the LDC 343274 minimum use determination as implemented in our package. Is that good?
Technically speaking,
No.
and also that it's consistent with
Oh.
the comprehensive plan.
Okay.
It's not,
I find
it's
it
not a rezoning,
consistent
but
with the
it is
comprehensive
consistent with other
plan.
sections.
Okay. With the proposed language modifications, yes.
Consistent with the comprehensive plan.
Yeah, with the
Yes.
mud provisions of the comprehensive plan.
Right here, a second.
I'll second it.
All in favor, say aye.
Aye.
Aye. Passes 6-0.
Wasn't that fun? Let's go eat.
And we're going to adjourn for lunch. It's 12:29. We're going to call the meeting back into order. And we're going to open up the administrative agenda, starting with Code of Ordinances, Chapter 22, Special Events Discussion.
Sure, I know Sarah and Councilmember Rex are going through and having conversations and making some changes, but we want an opportunity to kind of bring it before you all. There's been a lot of discussion at the council about what is and what isn't a special event, what is the criteria. There's been apparently revisions of this thing, the pendulum swinging back and forth over the years. So this is really just a first opportunity to get your input, anecdotal conversations, specifics about language, concerns, one way or the other, about the special event. I think part of it is trying to make it more usable, more defined. Right now a lot of it's based on attendance, which is a difficult thing to judge sometimes. Somebody can say 300 people are going to show up and they fall into a different category of special event permits, and then maybe 1,000 people show up. There's no way to monitor some of that. So I don't know, I was just saying the background of the conversation of special events. I don't know if you want to talk about where you're at or some things that you found interesting about the event. I don't want to put you on the spot.
No, I just came in, so I'm not sure exactly what
Special
you
events.
covered.
Special events.
Well, I mean, I don't know. what you
All I've
covered
said is
here.
it's kind of been swinging back and forth. There's been a pendulum of what is a special event, how should we define it. Sometimes special event applications go before the council and people ask, why is this here? Sometimes special events go off in the community and they say, why didn't that get approval? So we're just trying to mitigate some of that and get some clarity for everybody moving forward.
We're trying to adjust the way the code is written so that it addresses impact. So it's, if something is very, very low impact, like 2 people and an officiant on the beach getting married, that's really maybe not what we want as a special event. That may not rise to the level of needing an application and needing to do things. So really addressing things that will have an impact on the beach, such as parking, they may need to clean up, that sort of thing. So that's what we're trying to look at and figure out, well, and also location. In some locations, it may be very low impact to have a concert. Say it's at a location where they could easily have that, like in a church. Okay, so if it's in the church, is that a special event? So we're trying to address these issues so that if there are noise concerns, parking concerns, crowd concerns, safety, that we're going to address those, but otherwise keep it at the lowest level of needing to get an application in and review by council, that sort of thing.
Okay. Anybody want to start the discussion?
Just had a question, Sarah. Is this all new language? Or is this existing language that's changed, or this is the existing language?
Existing language, does it have strike-through underlined? No? Okay, so that's the existing language that we're looking to work with.
Okay.
So they have been drafting, but I wanted to get you guys started on input based on your experiences in the community, conversations with the community, things you've heard from council, whatever, to kind of help supplement that before a final draft comes back.
I think one of the scuttlebutts out there in the community is that even if you're in your private, way this reads, and this is what, kind of the joke is that if you have a small private party at your house, you have people parking in the right-of-way, parking there, you now have to get a special event permit. I mean, that's kind of been the joke around here because of how this is written. Yeah. Anything where there's more than, where parking is don't forget your, where parking is of, people are everywhere. I don't know how else to put it. You could have in my house in particular, you can put, even in the grass, you can only put about 5 cars. And if I have 10 people, then I've got people in the right of way and stuff of this sort. So it's been a joke about needing a special permit for it because my cars are out in the right of ways and other places like that. So,
You might be serving alcohol.
no, I'm always serving alcohol, but that's something different.
Well, and
But I'm
that's
not
a great-
charging for it.
And that's a great point. I mean, parking in the right-of-way is a safety issue, and so there's got to be a threshold that we need to consider as far as when does that trigger a concern. And every right-of-way and every road's different. That makes it even more
Yeah,
complicated.
but at the same time, though, a 25-person party or having 25 people over, think about your homes. You don't want to have to go get a special permit every time you invite a group over for the pool,
I have free on-street parking in front of my house, so I'm
What?
okay. I have free on-street parking in front
Yeah,
of my
well,
house,
we
so
don't.
Well, we don't.
I understand that.
Have you seen the big no signs?
Yes. So, I mean, it's with the right-of-way, with the pavement, safety, we gotta take all that into account. So that's all the conversation.
Yeah,
we're
I get that, but I think that this has gotten so, it's such a broad stroke to it now that this is, you know, people are out in the community are exactly that. I had people over the house and somebody goes jokingly, did you get a special event permit for this? But that's kind of the scuttlebutt that we need to rein in a little bit here, because that's not what this is intended to do.
Well, and I guess looking at the other side of that coin, what are the impacts? So if you know that you're going to have a bunch of people over and you know that there's going to be parking in the street, at what point, at what point do you want to make people get a permit? At what point do you think this is a problem? Is it a safety hazard? Is it an issue for neighbors?
Still,
So-
even if you get a permit, you're still going to be having people park in the street, aren't you?
Well, and you have, if you get a special event permit and you have additional vehicles, you typically have to find a way to park. Find a location where that cars can be parked, that sort of thing. So we're really coming to you to say, we're looking at this and we're trying to resolve some of these issues. And if you have some good ideas about how this might work better, we're certainly open to it.
Yeah, I've noticed that, I guess I never realized it was this complicated. I mean, I've read through it, but to me, it seems like there's a lot of, in the business that I'm in, it's a lot of programming. So there's what's called a conditional statement you can make. It's a if this and that, and it seems like with these permits that there's a lot of that. It's like a flow chart that just never seems to end. Well, now you qualify for this, now you go to this. Now from there you go to here, and it's where does it end? Where does it stop?
Oops, this is now, that triggered this one, now you're
Yeah,
back to the beginning.
and that's,
Something that we're considering is based on the size of the event that you're proposing, and so you're going to have different levels for your application. So if it's a very small scale thing, we haven't figured out exactly what range we're looking at, but we've been toying with a few options. But if it's at the lowest level, you need to submit an application and tell us what you're doing and when. The next level is you have to provide for, if you need to have insurance provided. So it steps up each time, and then for the biggest events, you have to provide for security, you have to contact the sheriff's department, that sort of thing.
But isn't this what this is intended for, is for those bigger mid to big events that actually have some greater impact on the community?
And that's what we're trying to figure out, at what point it has
Okay.
an impact that people are concerned with.
And again, remember, this is two different, right? You have administrative and you have the council side of it. And so right now, it's, I think it's on packet page 67, right, Sarah? There's, I mean, basically, you got to go to town council if you're 4 days or more with alcohol. So if you're 3 days with alcohol, you don't go to council. More than 500 people, and I think the discussions we've been hearing is maybe it's not that high, maybe it's not 50 or 10 people. There's got to be some kind of in between, maybe, I think is what Sarah's talking about.
But I think, Sarah, did you say for that smaller event that you just need to let us know what's going on? I wonder why we even need to do that.
Well, and that's where we're trying to make sure it isn't like 3 people hanging out at a beach, because does that impact anybody? No. You have a larger family coming that could have more of an impact than a very small wedding with no appurtenances.
For practical purposes, for that smaller event, for the town to know about it, what did they then charge a fee, or what happens? I mean, what does the town do with that information?
And I don't know how we're going to structure that.
Okay.
So that's what I'm saying. There's a small level where you're just going to have to make sure you clean up your garbage and you don't park in the right of way. And then, to the next step where you need insurance or you need to contact the fire department.
I wonder for that lower level, because I just think there's a big percentage of the community that would never know that they would even have to come in to let the town know. So therefore, they would technically be in violation of something if they didn't do that. I wonder if it might save everybody a lot of headaches just to exempt that first tier from any notification. I'm just thinking out loud.
Yeah, no, and I mean, we're certainly looking in that direction, and if you guys have any idea what where it really starts making a difference, what it is that we care about. Is it noise? Is it cars? Is it people? Is it trash? Is it some environmental impact? Where what do we care about with this application? What are we trying to resolve?
Well, the question to me is that, is there any way to even have a large family event at your house and not park on the right-of-way? Because otherwise, they're going to have to go and park in somebody's parking lot.
Well, I can tell you, in my community, you're not allowed to park on the street. We have 3 parking spaces that I have to park. If I want people over, I tell them where they can park, and people carpool, and that's the way we do it. I understand it's all over the island, so it is fairly complicated, but, I mean, that might have to be handled on a case-by-case basis, because if it's a small event, and you have people parking on the street and they get a ticket, is that better?
No,
So,
that's what I mean.
and that's what I'm saying, is, so what I'm saying is, if you're doing something that might rise to that level, what is the enforcement method for doing something that may not be legal? If you're parking in the right-of-way and that's not legal, I mean, so there is an impact that you're creating, and you're doing something that's not legal. If you don't like it, you know, maybe we need to find a different way to resolve that, because that maybe isn't through a special event permit.
I'm wondering if it would make more, I mean, to have, it seems like there's different voices who get to say what. Like, the town manager, after it's been approved once for an annual thing, now has the right to say yes or no. It doesn't seem like there's a streamlined voice of either it goes in front of council or it goes in front of staff or both, or.
I think that's what that process was trying to do, is once a council approved it into an annual event, then we can administratively do it. The reality is, most of these events have enough change from year to year where then is the town manager comfortable signing off on that, right? So then it gets to a why did we not see that kind of thing. So we're trying to clean some of that up, just to make, to your point, make it more clear for everybody what their role is. And I think some of the notification part, Mr. Adderholt's point was, which is sometimes knowing helps us allocate or not allocate resources as a town. If we know about a little event that we get calls no matter what, right? So we're getting the calls, we have to respond to those. If we know it's a 5-person thing that's happening down the street, we were made aware of it, or 10, 20, whatever. 5's kind of low. But we don't have to necessarily send somebody out to find out what it is if we already knew what it was until it rises above a certain level. So I think there's some benefit to not allocating public resources to investigate something if we know about it.
When you say you know about it, I mean, would you get calls for like noise complaints? Is that what you mean? 'Cause
No matter what
obviously
anybody's doing, we get calls, yes.
But is it generally noise though? I guess?
Noise, people are parking in the right of way all over my street, and it's one car. So we have to respond to those. So I think sometimes it's helpful for us to have some information at our fingertips. Now, again, the one car is an extreme example. I don't think we're going to be at that point, but you know what I'm saying? We get calls and it gets exaggerated sometimes, and sometimes it's underreported, and then we realize it's a big issue too late. So information helps us.
Regardless of whether you're notified or not, it's still going to be illegal to be parking on that right away, even
Right.
if you
So
have this
I
permit.
think knowing what's going on and what
If the town knew that there was an event and it was properly notified, would they be more lenient on that right-of-way, illegal right-of-way park?
I think it's knowing when it rises to the occasion that there needs to be more resources to investigate something. If we know something, if the parking on the right of way is not an issue, it's just a noise thing, but they happen to get a permit related to that, it depends on the time of day. Maybe we wouldn't go out there. If it's at night, yes, we would. I don't know, but information helps.
And a lot of times with the special events, when they apply for them, you know, they'll tell us how many cars, and then they'll sort of underreport where cars are going to go. And we'll say, where are those other cars going to go? You know, what are you doing with these? And it'll sort of encourage them to do a little bit more pre-planning, you know.
Cost of that first level, that smaller entity permit, just out of curiosity?
I couldn't tell you.
$50.
50.
Well, so there's supposed to be an extra fee because often we have people that come in a week before their event and want everything processed and reviewed, go before the council, so that doesn't work. So we have in the town council adopted fee schedule, there's an extra fee for if, I think it's 3 weeks or a month or something like that. If they're not out a certain period of time, then there's an extra fee to kind of expedite it, but $50.
I wonder, in the interest of comity with the community, as opposed to being adversarial with the community, I wonder for those smaller events, since it's just a need to, it's sort of just for our information basis, I wonder if that fee causes more animosity than it does in terms of helpful to have revenue to offset administrative costs. I mean, it seems like that might create tension I mean, that's the perfect example that the townsperson would use. I had to go over and pay $50 because I'm having a family reunion, and I just wonder if the cost-benefit analysis of that is on the upside for the town. I'm just thinking out loud.
That's a
No,
fair point.
and honestly, it isn't worth it staff-wise either. I mean, we're processing paper for what? You know, so we recognize that there's an issue with that. Yeah, we're charging people, and it may cover the staff time, but it may not. And also, it's a lot of work and a lot more than, we're recognizing there's an issue with it, and it isn't helping anybody. So that's one of the reasons that we're looking at this low level. What is it? Why are we doing it? At what point do we need to do it?
Have they provided anything when they come in for that low level, that things that could happen? Say parking in a right of way. Here's a list of things that you need to be aware of. If people are parking in the street, they could potentially get a ticket. You know, just something, a handout saying, we're not going to charge you the $50, but just so you know, this is a potential that could happen, so be aware of it.
Yeah,
So at least they
that's a
have
good
something
idea.
that
Yeah.
they know in advance. They can't come into council or anywhere else and say, oh, I didn't know I was going to get a ticket.
I think we have to define what the low-level event is. Is it an event with less than 50 people? Is it an event above 50 people? I mean, what is that number? Me having a pool party showing a movie in the back where I have 25 people back there, is that a special? And I don't mean to do that, but yet at the same time, this is what we're kind of talking about. You know, going out and taking 10 people out to the beach, getting married real quick and getting off, is that a permittable? And we need to define that better, because again, I think it's a lot of paper, it's needless paperwork for,
Sometimes
Let's
you have
simplify
to have
this.
turtle time sign off on a mid-island in the middle of the street part. I mean, that seems, and I respect the fact you need them to sign off on something that's on the beach. And then the fire department gets involved where, oh, hey, I'm gonna grill some hot dogs and some burgers, and all of a sudden I've got to go down the fire department, and that's another $50. So it would be nice if you could just, like you're saying, Sarah, if it's this size party or this size event, you need this. If it's this size, oh, you're gonna have, oh, you know, it's this. So I think it's cumbersome when somebody's trying to, like Jim said, when you're just throwing a family reunion, you're gonna have 20, 30 people over, then you have to fill out this mountain of paperwork. It'd be a lot easier for you guys too, if it's this
And we
size.
frankly don't get a lot of those. I think it's that small in between that is being missed, and we are, in my experience, getting complaints about. So I think basically it
well,
seems
define
like
that, wait a minute.
the floor is not high enough.
Give us an example of what you're saying
We
when you
get
say
noise
mid.
complaints about 30 or 40 people over at a party, or especially during season, if you got, some of that might be short-term rental issues, but, you know, if you got people having a party at a condo or something and there's a noise issue, is that a special event?
No.
Okay, well, we need to define that in here.
Yeah.
My point is, the floor is too low and the ceiling in this is too high, right? So it's 500 people before you go to council and 4 days of alcohol. Less than that, 490 people, however they're defining that, and 3 days of alcohol doesn't supposedly
Okay,
go
so
to council.
here's a question.
But then everything under that doesn't go to council, or doesn't get it requires a special event too.
You have 100-person wedding here. Alcohol will be served over 2 days because you've got the
Where?
pre-party. I don't know.
Fireside.
Meyerside. I don't know. But at the same time, no, 100-person wedding, technically alcohol is going to be served for a couple of days. You know, does that deserve a permit or not? Because, you know, it's 100 people. Alcohol's going to be served on Friday for the rehearsal dinner. It's going to be served Saturday at the reception and Sunday at the brunch.
I also think zoning matters, and I think approvals for certain things matter, and there's certain uses and places that have approval. Banquet halls, for example, shouldn't necessarily get a special event permit because they're hosting a banquet. So I
But do
think,
they have to have one now in this code? That's the question.
Right.
If they're,
I don't
But
believe
does
so
Diamond
if
Head-
it's
they
within their
don't need a
use.
special event
No.
permit if they're hosting a wedding.
right, I think some of the bed and breakfast questions are gray area, and then obviously the residential is a huge gray area, or not even a gray area, it's just, you know, parking on the street, again, all these things, the party gets bigger than was expected, causes a neighbor complaint. Why didn't they have a special event permit? Establishing that and defining that is a key part.
yeah, just trying to figure that piece out. I mean, go, sorry.
No, that's all right. Is there anything in place that if I come in, to use the chair's example, to have a 100-person wedding, that I'm required to let my neighbors know that, you know, I've noticed that when you get certain variances, you have a bubble of people that you have to make aware of the situation. Is there anything that we do now that requires them to let them know that maybe that would ease up on some of the calls that you may or may not get?
I saw this.
So yeah, I'm trying to remember, see,
it's-
unfortunately Patty administrators all these. so-
22.8,
She's jumping out, I see her.
F
in here.
6.
So exemptions.
It's in here.
Exemptions include private events that make no use of public property other than lawful parking. So if you have a parking lot and you have space for everybody and you're using a private space, you don't have to get a special event if it's within the use.
This must be her specialty area.
Yes, I was coming in. Paige Prevost for the record. I do the special events. So different things trigger different needs, okay? You can have a family reunion at your house on private property, but if you're having 200 people, you need to have a parking plan. I need to know where you're gonna park. So if you can do the park and ride, that's great, we don't have a problem. But if you're gonna have amplified music, then you have to send notification with a due date of when they have to let the town manager know that if they have a complaint with that. Okay, so like, and I always tell them, make it 2 or 3 weeks before the event, because that's gonna hold up your event permit. So if you do it like, okay, 2 days before your event, I can't give you a permit until that date comes and goes, and if there is or is not a complaint.
What's
Does
the
it make
protocol if there is a complaint?
If there is a complaint, then we revisit it again, if it's a reoccurring thing, like every year. But reoccurring does not mean that, from the town's standpoint, the only reoccurrings we have are farmers markets and the sunset celebration. That's a reoccurring. Just because it happens once a year, that's not what we define as recurring.
So like shrimp parade and things like that are not reoccurring?
No,
Okay.
even though they do it
Happen
every
every year at the same time, okay.
So,
Go ahead, sorry.
I just was going to ask, since you're on the front lines, what would you suggest we do to make things better?
I have been working on this for 5 years, trying to make it easier, and it always goes back to, but you have to have this information. So it's very cumbersome, but at the same time, a lot of it protects the town and the people having the event. So I don't know what the answers are. That's why we're coming to you, because when I first took this over 5 years ago, they asked me to redo the whole application, make it really simple, Patty, and I did. But I made it so simple that it was just, it probably would have been a free-for-all, because you can't, everything triggers something else, that's the problem, so.
I also believe that there's been events that have been better because of the information that Patty has hounded them for, frankly. I think the boat races, when going through our process and with the council, and all those questions the councilor was asking were related to things that Patty probably asks on a general basis as soon as she gets the application. So, I mean, I think events have gotten better because of it. But to your point, bigger, that makes sense. And the impact, I think to Sarah's point, the impact matters. But small things, what is that threshold?
Thinking of those smaller events and what Dan suggested in terms of, hey, if you come and register for a small event, here's a little fact sheet from the town of things to be aware of that could place you in violation, FYI. I would certainly be helpful to people who don't know the island very well.
I think it's a great idea, regardless of if there's an exemption from having to submit something for a small event or not. I think having that available would be a good.
Especially on the parking, because that is typically the biggest thing and the first thing that gets hit.
Stop parking in the right of way.
Parking and noise are.
Yes.
And litter.
And litter
And just-
are what motivate the need to have the regulation, and in a small community like Fort Myers Beach, it's even more exacerbated or amplified, particularly when you get into side streets where some of the streets are really narrow, and parking. That's the complaint that staff gets, is the neighbors saying, gee, I couldn't even get down the street, and if they're parking on both sides of the street, then there's the concern of getting emergency equipment down to someone who may need it, and it can't because the road is blocked.
But do you think maybe putting that on the town website too? Okay, if you're gonna have a party, you need to make sure parking is addressed. When we have things at our house, I try to be a good neighbor. I try to let all my neighbors know, hey, we're gonna have some friends over. Is it okay if they park, I even ask, hey, can they park in your driveway? I try to get them off the street, and afterwards, there's always some idiot that throws a beer can down or something. You gotta be a good neighbor, and I think if you had that information on your website, hey, if you're gonna have an event or a event at your house, here are the things you need to watch out for. You need to make sure parking, encourage people to Uber, encourage people to use public transportation, carpool, do all that, and that's what we try to do, ride your bike.
But I think, though, that by this, right now, the way this reads, you technically should be getting a permit for that. And that's what. but
Right,
you
yeah,
don't- And I think that that's needless paperwork for that, rather than being a good neighbor and doing exactly what you're doing. You technically would have to come in here, pay your $50 and get a permit for that party. And,
100.
but again.
No, I agree, but
But-
just hey, we're, just like you have your little pool
Yeah.
events, you get 20, 25 people over
Yeah.
there and like that. So I don't think you should have to get a permit for that every time.
Yeah.
Well, no, if you're having something at your house on your private property and you are not affecting any parking issues, you don't have to have a special event permit. And I have not given any special event permits. I've had tons of calls of, okay, we want to do this. I said, are you on private property? Yes. So as long as you are not affecting parking, you're not parking all over the place, the town doesn't have a problem with that. Problem with the little ones, like two people getting married out on the beach, the problem is okay, we want an arch. Well, now you're putting something in the sand, and you're having it at a beach access. Town needs to know that, because sometimes they have to do work at the beach accesses, and they've come to me, Public Works has come to me and said, okay, we want to work on this beach access. Are there any weddings this 2-week span? So, yeah, that's where it starts getting, you think it's 2 people, who cares, but sometimes it matters.
Roxanne?
I just wanted to let you know that a little background. Sarah, Patty, and I have met on this several times and really worked through a lot of things that you guys are already discussing. I had asked that this come to you, and they probably were thinking the same thing. I don't know who said it first. But what I'm looking for from you is, we had our 3 brains on it, but what I'd like to hear from you is, have you heard of a specific instance where there is a problem that we need to address? Because we're not going to think of all of those particular bugaboos. And to give you an example, Sarah mentioned that the library had to come in and get a permit for a book sale on their property because of the size of their sign. That was the only thing that brought them in. So we're looking for examples that you may have heard of where something didn't seem right, that your neighbors have told you about. So please feel free, if someone comes to you in the near future, this isn't our only discussion time. Email me or Sarah or Patty if you have a thought after this that, hey, somebody came to me and said, we had to get a special permit and it didn't seem to make sense. Let us know those things. I'm looking for things that we may not have thought of.
I've got one off the top of my head.
Okay.
Last year, there was an event at Myerside. Was it Otsego Bay?
That's what actually started this whole
okay.
process.
All right, okay.
That I got a complaint about that, and that's what led me to ask that we deal with this issue. So that when we do.
So in your opinion, let me ask Patty this. In your opinion, would an event like that need a special permit?
Is that a use issue?
Because it was
It was outside their use. A bed and breakfast is allowed to do certain things, and they aren't allowed to do certain things.
would have been on your private property, it wouldn't have been an issue.
I guess the bigger question, now you bring that up, is that I rent out the bed and breakfast for a wedding, and I want to have a reception there. Does that fall within their use or not? Would that need a special permit? I mean, I guess that's where it's kind of, to us, the struggle I have is what's a permitted use under this and what's not? I mean, it's a party to me, it's an event.
I think we're going to come back to parking in a lot of this again.
Okay.
Because again, if that, in theory, that site and that use has sufficient parking in theory to accommodate who's there. Then you add in 200 other people, 100 other people, they probably don't. So, and again, each site's going to be a little bit different. Women's Club has more parking or less parking than somebody else, that kind of thing. So that part of it matters, I think. So I think we're always going to come back to somewhat of the parking as a big driving force in this.
I think we're just asking the questions because we're trying to get our head wrapped around what's considered an event and what's not considered an event. I mean, if I can park them all on my private property and I'm good. I can
Do
throw
anything you
anything I
want,
want.
yeah.
It's
As
pretty
long
much
as
what
you're
I
not
think.
too loud.
Yes,
And you have the noise ordinance.
So it really comes down to impacts, like, the Meyer side issue, that was about impacts. Like if Mango Street Inn, they've come in to get a special exception and their use is very specific to what it is. It's not a conference center, it's not a banquet hall, it's not those other things. It's in a residential neighborhood and the expectation is it will be a residential neighbor. But if they expand beyond that and they're having impacts on their neighbors, especially on a regular occasion, then that could be problematic. So, just figuring out where these issues are and at what point we need to make sure that the town is involved or aware.
Do you have anything we haven't heard from you?
Sitting here listening to everybody, it kind of comes back to, we have different, and call them for events, and some of them being of a personal nature. So you look at it, is it a personal event or is it a commercial event? So there's the first two categories you want to look at. To me, on the personal side, or individual events, as an example, Megan wants to have a dinner party of 6 or 7 people. That's inside the house, no problem, should not require anything. She wants to move it to the outside back patio, no problem, shouldn't have a problem. You want to have electronic or amplified music, and this is one of the categories that you want to look at. Amplified music, no matter how many people you have, whether it's 5 or 500, you have a noise ordinance. That's a break right there. Parking, whether you have 5 people for the dinner party or you have 50 people, parking in a right-of-way, that's a breakover right there. And it's not because it's part of the event, it's because it is controlled by some other agency. Primarily the sheriff's department. They're going to come pay you a visit. So that really doesn't make any difference. But I think if you look at the private side and give yourself a limit of saying, okay, how many people really can you have before you want to start getting into a permit condition? Because some of it's, like you said, 20, 25 people going to watch a movie. Well, they're not making any noise, that they're not going to have any problem as long as they don't park on the street. Everybody's fine, everybody's happy. But if you want to have a keg party and there's amplified music and there's only 15 of it, well, wait a minute now, we're coming into another category here where you're having amplified music, because I know you love it, honey, I know you love it. So, I mean, you have to break these things down and look at them for, at the individual side. I agree with you that there is a certain threshold where you really shouldn't need to come to town and say you have anything because it's in there. But none of that is being listed here, and I think that's where we really should start. What is it we really don't want to get involved with? And it's the private stuff, what you're having inside or in your backyard. Now, where do we really want to get involved? Well, if you're going to have amplified music, or if you're going to have parking on the street, things of this nature.
Can't have
And
parking on
keep
the
that
street.
completely, the impact side, but keep that completely separate from the commercial side. To me, a commercial event is anytime you want to advertise or you have donors or anybody else that's in there. It's not of a private nature. I think strictly there, yeah, you got to come and get the permits. If you want to have the amplified music,
it's like everybody else, whether there's only 5 people or there's 50 people, you run the risk of having it too loud and the sheriff's department's come see you. That's not something we really need to get involved in.
But I think on the
we
same
have a
token,
noise-
excuse me, if you have just amplified music, it should be, hey, I'm having hopefully X amount of people, I'm gonna have amplified music. What does it cost me? I don't wanna fill out 28 pages. Could we find a compromise there?
So that's what I'm saying, as far as if you're having it and you're staying within the limits of the law, what is the issue for a permit? Are you going to exceed the limits of the law that you need a permit for as for an exceedance there? Or are you going to stay within the limits of the law?
I just wanted to note that the private versus commercial is an interesting way to look at it, but we also have, and I've suggested in our meetings, we have the nonprofit component, so it's more like a commercial event, but I want to be kind to the nonprofits of the beach that are having an event that they're already trying to raise money for a beach cause. I don't want to be charging them a big fee necessarily for having an event where they're trying to raise money for something to improve the beach. So I just wanted to point out that I think the nonprofit interlocks with that, and it's kind of the PR aspect of it that Jim mentioned. Are we causing more ill will by charging for something when maybe with our nonprofits we should be a little kinder to them because they're already trying to help out?
Like a beach cleanup, are they required to get a permit because they all gather together and pick up or turn in their trash or something?
I don't know whether they've been getting permits or not. I don't think so, but we have a
We
lot of
have-
cars here.
Well, as long as they can cover the parking, we say no, because they're doing us a huge favor by cleaning up our beach,
Hey,
so.
I mean,
Again, I think Patty will tell you, she has to ask 10 questions and drag it out of them, and then eventually we come across, well, yeah, I was gonna do this and that. Well, then that triggers,
And it's always a trigger.
there's always,
It's like the amplified music. Even if they're going to stay within the noise ordinance levels, they still have to send out notifications to 500 feet from where they're having it. As a courtesy, well, if you just had a baby and your neighbor is going to have a party and have amplified music,
But if he stays within the noise ordinance, it doesn't matter if I turn the radio on or if I have a band out there.
There should be no other trigger.
well, that's one of the rules, and if
that's where I think the
if you
police should,
wanna-
the sound should affect it as opposed to coming in and saying, I'm having a birthday party, and when we sing happy birthday, it'll be loud, but everything else will be because we'll be
if they
whatever.
if they get caught. If they can call the sheriff's department, and if they exceed it, then they can get a citation.
I mean, we had the cops come one time when we were singing happy birthday, after we sang happy birthday because everybody was singing together. And they walked in, I said, well, oh, please come in. It's a guy, 72 years old. And, we're really wild out here. They walked out and went, sorry.
They
But,
called the police on us
they-
in
yeah.
Christmas caroling last year?
Oh, is that right?
No, they actually gave us a police escort. We thought we were in trouble, but they
Okay.
they came and told Santa that they wanted to escort us down the street, so that was very nice.
I guess what we're kind of getting at, and I think this is where we've started this and we're kind of wrapping around to the end of this, and the same conversation, is that, one, you guys need some sort of direction as to what do we consider the minimums here on needing the special event permits? What triggers in here are kind of, we don't agree with? Am I correct on this, is what you're looking for from us?
Right.
So like the amplified music, if you're within, it sounds like if you're within the noise ordinance, we all kind of said, tough, we're within the noise ordinance, then we can have
And you're on your private property.
and you're on your private property, so I think that's what
And
we're
you're not
looking
parking
at.
the right of way.
We're not trying to, the private party, the private birthday party, the private pool party, the private party, we're not trying, I don't think we, as an agreement here is what we're trying to get at, and we're
Well,
trying
and
to find.
I don't give.
You don't
I
need
don't-
one.
I don't
I know.
give permits for that.
But you
I've
look at
never
this
had to.
thing, and it
Oh.
kind of defines that you do.
Tell me about it.
So when you're looking at the language, I think there's a greater hole on this board here. We're saying if it's a private party and it's a small private party kind of deal where if it can be handled with internally and we live within all the current ordinances we have on the books, shouldn't need a special event permit.
So,
Am I correct on that?
yeah, I agree. I mean, like a boat parade party, you have your iPhone hooked up to a speaker. Is that amplified music?
Technically, yes.
So, oh, come on.
So that's what we're saying, is
We
that
didn't
as
write
long
it.
as, but,
We didn't write it.
It's gonna be even bigger with the boat race. Every beach house, after
But-
seeing what happened, they're gonna have a party just like all the houses on the
Sure,
back bay
but as long as that's
are having
under
little
the-
get-togethers during the event.
but
I
as long as it's
find
under the
it,
55 decibels, who cares?
I find
that's
it
what I think.
insane that every house would need to get a special permit if they've got 50 people coming over to watch the boat parade or the boat race. And same thing on Shrimp Fest Day. You're always gonna have 20, 30 people in front of your place if you're on Estero watching the parade, and they're probably gonna be there before the parade and a little bit after. I don't think every business needs to get a
Move away from my
permit.
property because I didn't get a
Well,
permit.
the only thing that we asked for the Roar Offshore was for the commercial properties that wanted to do,
Yeah,
you know, either a party or close their parking and
I totally get
sell
that.
parking. And I got a deluge of permits, and they all came in like at the same time, and you're trying to keep them all straight, and you're trying to make sure they all have their insurance, which even for the small events, you have to have insurance because it covers the town.
But I think
You
for
know,
direction and purposes moving forward, as you're looking at this and changing this, you see where we're going with this, is leave the little small private parties alone as long as they can handle on their property, live with the ordinances we have on the books already. And then that way, let's get that out of the mix. Am I agree?
In agreeing, I would just add to that too, I would have the town consider for even those that have an impact that are smaller, I would consider waiving that fee, still accepting the notice and utilizing that information, but waiving that fee because I think that creates, again, tension between the citizenry and the town that I don't know that has value. And I think, as Roxanne said, the not-for-profits as well, when they're trying to raise money or support a cause that benefits the beach, to charge them a permit fee, again, seems sort of hostile to these interests. So it's just something to think about.
We were also thinking about a tier system for the fees also, weren't we? Yes.
Couldn't you break it down to if it's non-for-profit? If for not-profit, then there's no fee, but if it's for-profit, there is a fee. And then you
One
can.
of the things we were looking
Right,
at.
well, there'll be,
I would
Right
say
now, I
smaller
think when we're really looking at this, and we've talked about, and Roxanne come up with a very good category, but we can come up with as many categories we want to fit in here as we like, and nonprofits be one of them. I think we're in a stage right now where pretty much we've got some good direction, but a blank sheet of paper. How do you want to set this up? I think that's where we're at right now. I mean, Jim come up with some ideas as far as, okay, for the private stuff, it should be, hand them out a piece of paper saying this is what our current regulations are. As long as you adhere to all of these, there's no problem. Go have a good time. But I think what we look at as far as all the different categories we could and come up and start basically there.
I really feel like I've gotten from you what I need. I've got a feeling of where you're going with this. I think Sarah and Patty agree. We just wanted more input and backing, but I still encourage you to contact us if you have another circumstance arise that you want to communicate with us. Please let us know.
I think the key to
But I've gotten the feedback I'm looking for.
Okay, but I think also the key to it too is on private property. So different if you're going out to that beach. Yeah.
For whatever it's worth, and the beauty of the internet, while you all were talking, and I just simply opened my search engine, typed in special event permitting, Florida, and I just came up with and brought up two beach communities, one on the East Coast and one of our neighbors, just randomly, frankly. To give you an idea of what they consider to be special events. The city of Melbourne, East Coast, beach community, their permit application says a special activity or special event, an event conducted outside on public or private property with a limited duration, infrequent occurrence or seasonal nature, An event where it can be anticipated that the number of persons attending will exceed the available on-site parking. An event where it can be reasonably expected services will be required beyond those that are regularly provided. Additional police, we have a similar trigger. Or an event that will impinge on adjacent areas, including amplified sound, athletic events, carnivals, circuses, concerts, fireworks, high-intensity lighting, musical groups. So they have 3 of the triggers that we have in our code. The definition of a special event for the city of Sanibel, next door. Generally, special events are temporary uses that extend beyond the normal use and standards allowed by city ordinances that are held wholly or in part upon a public or non-public street, city right-of-way, or any public or non-publicly owned property. A special event can mean, but it's not limited to, sale, grand opening, wedding, photo shoot, party, holiday celebration, bazaar, concert, or other performance. Not bizarre, bazaar. Tent, revival, fundraising event, art festival, race, tour, rally, parade, bicycle run, demonstration, contest, exhibition, block party, outdoor display, or similar event or occurrence. So it again has similar triggers to the
Fun to Roxanne.
So,
yeah,
We're done.
yeah, so
we're in the
Wrap it
ballpark.
up.
It's just the thresholds, I think, is where we're working on. Any other
Okay.
input?
Done. We're
Done?
good.
We're
Thank you.
done. We're
That's good.
wrapping it
Yeah,
up.
like she said, please let us know, Sarah know, Patty know. If you come across people talk about these things and they give you some enlightenment, please share it with us.
Okay. Next item on our administrative agenda. Places of worship, religious facilities, LDC discussion.
So, Jason Green, Community Development, essentially I try to lay out for you some of the, the existing definitions and what the code, I guess, asks for now. Some examples, I have some experience dealing with this issue in other places, and again, everybody deals with it a little bit differently. Pros and cons to the places of worship versus religious facilities, and then obviously I think the conversation is, should they be lumped? Should they be treated differently? Should there be different thresholds that maybe administratively we could allow? I think some of it comes back down to zoning and what you're adjacent to also. Residential, kind of similar to the many conversations we've been having today. Are you adjacent to residential or commercial? But essentially, the places of worship is, the church itself, where the worship is occurring. And then religious facilities is essentially I believe, contemplating all the other things that a place of worship might also have going on their property. So right now, as I said, currently, the LDC defines religious facilities as a special exception use in certain zoning categories, and places of worship would be a permitted use. I believe that the code is set up treating them that way, partly because it views those other uses that fall under religious facilities as potentially more impactful. But then again, some of these could be shifted into under worship, or we could split them up differently, could leave it the same, could reconsider what zoning districts they're allowed in, could limit it to only if it's adjacent to residential. It's open opportunity to rethink this. The only thing that we can't do is change where you permit places of worship differently or more restrictively than you do other clubs, VFWs, or other type similar organizations. You have to treat them all the same. So that's kind of what I had on this. Hopefully you read the memo if you have any questions about that. And I know
I just wanted to jump in and give you a little background.
Great.
The Beach Ministerial Association asked me to talk to them about this. They have had long, serious discussions. All of the pastors on the beach, with the exception of the Catholic Church, has not attended, but all of the other pastors on the beach have attended these meetings, and they are very, very concerned that they have a future problem on their hands. Since the town has been doing more enforcement of different types of issues, they read about it in the paper, and they're afraid they might be next. So they became very concerned, and I did a little research, and I found these two categories, places of worship and religious facilities. Part of their discussion has centered around the fact that times have changed. in the same way that we had a code that didn't contemplate the fact that our houses were going to be built up because of flood regulations. Times have also changed with churches. People no longer just, well, people don't come to church if they have a church where they just go and pray on Sunday morning or Saturday if they're Jewish, whatever. I try not to use inappropriate terminology. We don't have a synagogue yet on the beach. I'd like to see one someday. But what they say to me is that churches no longer are just a place where people come and have a worship service. People come for activities. And so they cannot sustain a church anymore unless they have activities at the church, and the churches also do mission kinds of things. So if back when their building was built, if they were designated a place of worship, they don't use the sanctuary anymore just for worship. They do other things in there. They, have the things that fall under religious facilities occur in the sanctuary building now. So they're concerned that future enforcement might come about because of that. Now, what I did find out from talking to Sarah, I believe some time ago, and you can refresh my memory if I misquote you, I don't think any of our churches, because of the Lee County town thing, our churches don't have a designation. I don't think any of them do. So they're just all zoned institutional, I believe, but haven't been given either of these categories, and they're worried. They want some kind of...
They also do worship in the facilities, too?
Yes.
So that's, it's
Yes.
both.
So one of the ideas has been that we don't need two categories. We just need one category that really looks more like religious facilities. And I know that has some concerns with staff because they're worried about the impact on the neighborhood, et cetera. But the problem is none of the churches on the island have ever been designated either one of these. So in my opinion, nobody's violating anything at the present time. But they wanted this to be talked about. They want to be reassured that there's not going to be a future problem coming down the road because, like I said, these were written in a time when churches behave differently than churches behave now, the same way that our houses have gone up. There was a change of times. The code doesn't seem to have been modified to go with how times have changed.
Yeah, Steph agrees. I mean, I've got some experience, City of Lakeland, working with that, where basically a church has become, I mean, they're cultural facilities. They're not just religious facilities necessarily. They're Y basketball programs, all kinds of different things going on them. And that's where my experience comes in with light, noise, traffic impacts. But that being said, I think that's what we're trying to figure out and get your input on is maybe some of these move over, maybe it all combines. Maybe some of those more intense uses get identified as not being included. Just
But we
open to
can
some.
limit, so if we did do a religious, combine it and made it religious facilities, we then could look at the overall total usages that are included under that and make limitations and changes to that, or am I
Right,
following that
so
correctly?
let's use one of the things that are listed under a bus storage facility as an
Yeah,
example.
that's
Okay,
kind of,
is that something that you want to automatically include, or is that something that has a greater impact? I think the missions, I think, what else is in here? You have retreats as a term that's in here, monasteries, convents, rectories, monasteries, and all of a sudden retreats are thrown in there. Well, is that daily? Is that weekends? Is that running like a motel, hotel? Those are the kinds of things that come to my mind, but I think clarifying some of those will help you decide where it goes. So that's kind of the
But their
question.
concern also is, then if we make changes, are they all going to be dragged in and told that they can't be doing the things they've always been doing?
Right.
My position is that I think that we need to do something all-encompassing that says, what's been happening on the beach at this point really hasn't been a problem. I know there are a few complaints always about certain things going on, but overall, we have not had a problem. I don't want the churches all having to spend money to come in here and get special exceptions and have things defined. I don't know if there's some way that we can do something that...
But there must be some sort of risk reward, I guess, because they run the risk right now.
That's
Now
why
they're
we're
coming-
trying to clean it up.
Yeah, and now they're coming in front and saying, let's clean this all up, but yet we don't want to make,
Well, but at the same time we clean it up, I'd like to have some grandfathering included with the cleanup, is what I'm saying.
We don't want to lose services that they're giving already to the community and to the
Right.
families and to the you know, I think that's the important issue. That's what I ask the question of, is there an issue that we're trying to stop? And I think the point is, no, we're trying to make legal the things they're doing so that they can continue to do them. And I don't think there's an issue now, but by putting it into a classification, we stop it.
And that's fine. I'm more concerned about the broad stroke of this, is going, okay, we want to include everything that we're currently doing. Oh, yeah, by the way, we want to add all these other uses is on top of it, too.
No,
So
that's-
that's my concern on all of
Yeah.
this, is that, you know, you be careful if you want us to fix this.
But
We
when you
can
go-
fix this, but there's going to be some
Right, and
fixing.
that's why this is a preliminary discussion, so that you guys are aware of their concerns and et cetera. And just one other thing I wanted to point out, there was kind of an emphasis put on the word retreat in here, and there is a retreat at the Beach Baptist Church. And so things happen there occasionally in a retreat sense. But what a lot of people don't know is that we have a convent which exists at the Catholic Church where people are living 365 days a year. Right now.
Well,
So if you start regulating the retreat, then are we going to be throwing the nuns out?
Yep.
Because they're,
I think we're sensitive
So-
to trying to interpret and define those two. I mean, I'm very sensitive to religious facilities. I know how much protection they have under federal law. So we don't want to get involved in trying to, I mean, you know, John's explained the difference between monasteries and retreats to me.
Yeah,
There's some fine line
we're
there
just
for-
talking about that. There are some fine lines, you know, as someone who was raised and went to a Catholic high school, run by an order, you know, monastery is where the monks and the fathers live to the exclusion of others, you know, and same with the convent, you know, you can't have non-members of at least generally as I understand it, there may be exceptions. And we can work around those and make the definitions fit to what is currently taking place in Fort Myers Beach, which is what Councilmember Hasselfrost is trying to accomplish. We understand that is to account for what's currently taking place on the beach and you know, make sure that it's all done properly. And you know, to the extent that you all have some specific suggestions or ideas in that regard, that's obviously the purpose of this conversation, is to get your input and thought if that's the direction you know that we're headed.
Based on the conversation we had in the first case we heard today, this sounds similar to when we start using words like grandfathering and doing what's always been done. Do we have to be careful of how we go about this so that it doesn't affect something else like that? I don't know if I worded it.
I think you're moving toward making it more permissive, I guess,
Yeah.
use it again. I mean, we're talking about combining more uses. Where's that threshold of what gets permitted use versus special exception use, or however you want to go about it? I think we're moving more towards including some of those uses versus away. Almost the opposite, sorry.
I feel like the key here is the same thing that we talked about with special event, is mitigating impacts. You know, what impacts are created from a church versus what impacts are created from these other activities. You know, if you're allowing a school, well, a school is, that's 5 days a week, that's buses, that's lots of, you know, you need to think about what the additional impacts will be and how to mitigate that. So we're not thinking about it as a use like, oh, it's a church. We're not thinking about a religious aspect. We're thinking about traffic, light, noise, those types of impacts, and what we do to ensure that the neighborhood isn't overly impacted.
And that's fair, Sarah, but these are such unique institutions given unique protections that I think we need to err on the side of protecting what they're doing currently. And I think I appreciate what the counselor is doing here, because I think this potentially long-term could be a problem. But short-term, it seems like, I mean, I appreciate the work that the staff has done, but this seems to be some really important legal terms of art here that need to be put together appropriately so that we could look at. Because I think how you draft this will be probably as important, if it's tested in the courts, as anything that we do here.
Well, the general rule that exists both under federal and state law, there's a federal statute, and Florida's adopted a very similar state statutes. You can't, it basically boils down to you can't discriminate on the fact that it's a religious institution. and we're not. At this point in time, we are not discriminating. What we're talking about is, established uses that the question that is part of the motivation, or one of the reasons behind this, is that there are changing dynamics in some of these institutions, and they're seeking to be more inclusive for themselves and for the community. And the question is, how do we go about accomplishing that while mitigating potential impacts to the rest of the community? Because in most instances, not just unique to Fort Myers Beach, but in general, churches and religious institutional facilities tend to be in near neighborhoods where their congregation comes from, and so you're balancing that. What the law says is you can't prohibit them from being in those locations, but you can reasonably, and as long as you're not doing it in discriminatory fashion, you can regulate them.
And I appreciate that, but I guess my suggestion would be respectfully is to err on the side of protecting those institutions as opposed to protecting the neighborhoods. Not that they're not, they're mutually exclusive, but I would think as we draft the language, it should be to, again, err to protect these institutions and what they're trying to, what they're accomplishing. But that's the only sensitivity. I'm not saying you're trying not to do that.
No,
I'm just
I
saying
would never recommend you all
I know
to-
you're not, and I'm just, what I'm saying is we discussed this though, and we discussed the legal language that's going to be utilized for this clarification or ordinance, whatever it ends up being. I think we need to be really careful because legally, as you know, this could be a real can of worms.
I mean, not to get too far in the field, is the prior discussion item, special events, and this one, one of our religious institutions comes on a yearly basis for their renewal of their annual special event permit, because they do provide that for the community, the farmers market, and so we understand that, and we're trying to accommodate that.
So I think it's noted.
Question?
I guess I need to back up a little bit for something that I didn't say. When I originally brought this to the town manager and asked him to discuss it with staff, the answer that I originally got was, there's nothing wrong, we don't need to fix it. So that's when I then went to town council and said, there are people in the community that really do believe this needs fixed. Could I take it to the LPA and see whether they agree that it needs fixed? So I guess what I'm looking for here is, do you agree that we need to do something with this? Because initially staff was saying it was okay as it was.
I want to be cautious of being respectful. I don't think that's how we were intended to categorize it. So I do apologize if it came across as that. I think our initial response was it's typical to have the separation between. I can see things on this list that probably easily slide over. Our concern is the impacts. I think Sarah already said that. Traffic. Again, I have a background
Maybe I
experience.
shouldn't have said staff. Maybe I should have said the town manager.
I think we want to tread cautiously for both, all the reasons that were just said here, the religious purposes, and also I've seen the religious facility turn into 80% being all extracurricular activities and outside events coming into a neighborhood, and it really impacted the community. They had lights up on the outdoor basketball courts that were on until 11 o'clock at night. There was cars coming and going. Those are extreme examples, but that's what I don't think anybody wants to see that in a neighborhood, residential neighborhood.
But
So
you address that in with uses.
I think we need to clean, but what I don't think this does is go far enough in addressing those specific issues. And maybe it goes too far in not having enough of these uses over in the place of worship side. But kitchens and food service is another example that's not really addressed in this. Is that a use that should be common and normal as part of business for a place of worship, or is it something that's an extra use that gets counted as a restaurant? And so
No.
they have to go through that. So those are the kind of debates and questions that I think we need to be thinking about too. But no, we agree that there's some adjustment to this.
So what you're looking for from us is just say, yes, put some language together to broaden this and make it more user-friendly for what we have existing on the island is?
Yeah, and I think we're looking for your experience. Is that right, Roxanne? I mean, basically, you've experienced these.
Like I said, I was given the strong impression that nothing further was going to happen to this based on my request. So then I went to town council and said, I really would like to see some action taken. Could I take this to the LPA and see if they agree with me? So I guess what I'm asking for is, do I have a consensus here that this is something that needs work, or should it be left alone? And if you say it's going to be left alone, I'm taking that back to the pastors and saying, the LPA is saying it doesn't need work, so.
In my opinion, I think that it would be beneficial for the churches to all get together and write down basically the kind of services they offer and what they want to have, kind of basically an
An outline.
overall amen on, you can have it, go for it, kind of thing, just so they don't feel like they're supposed to be getting something or doing something, or that is this a correct use on this property? I think if they came up with a list of things that they do on a normal basis, that they would like to just be under this umbrella, then, if there's something that pops out at us like, I don't know.
I guess the question she's asking us is, does the current code that we have on the books and them as an institution cover what they're doing and we don't need to make any changes? Or as a group here, do we want to create a places of worship categories and clean this up and give them their own designation?
And I think that is the question,
That's the
Madam Chair. And I think the challenge, of course, to answer that question, of course, is a legal analysis. And I'd have to yield to Rexanne. Is there enough protection currently legally, or do you believe, or do the churches collectively believe that legally they feel like they have some exposure? Because if they have some exposure, if they feel that way, and there's a legal reality to that, then I think we should act. But it's difficult to know, because this really is a complex legal question in terms of their exposure.
Since I'm not certified as an attorney in the state of Florida, I cannot answer a question that
Good
says,
job.
legally, do you think? But what I want to say to you is that the pastors all have a fairly deep-seated fear that there's going to be a problem. And, I don't know how to deal with that. My gut reaction as a person, not as an attorney, is that we need to combine those two categories into one, and that part two needs to be that the churches, as Jane suggested, come in with a list. We're already doing these things, and then the town says, and those are all okay.
Yes, I think that's
And then if
smart.
they add to that, then they would have to come, and if they add to it and it doesn't fall within our new category, then they would need to come in and take some action. That's my gut reaction
I
of
agree,
what
and
should
it
happen.
gives some protection, a little umbrella.
I agree that there should be more discussion involving this. My question to you is, are they aware of potential consequences that could come from it? Maybe they lose some privileges that they have now?
Like I am
consequences.
asserting,
That's what
and
I
they
meant, yeah.
are asserting that they should get to continue to do what they are currently doing. And then, of course, that list would come to the town council and we would yay or nay it. They wouldn't just get to decide it, they would bring us a list. So
Well,
the fear is great enough on their behalf that they brought this to your attention, even knowing there could be some unexpected problems that come up.
I wonder if there's even some of these things being done, right? So to us, schools is a big thing. Schools are, the code looks at schools as being a school. Doesn't matter whether it's religion. Here they get a benefit of having 100 or less children. You can do that as part of a place of worship for a school. More than 100 children, because again, the impact, it requires a special exception. In these zoning categories, a public school, obviously of more than 100, would have to go through a special exception process too. Is that an issue? Are they doing that of more than 100? I don't know, maybe some of these we can check off and say, it's not an issue, so let's reevaluate those. But the rest of my, yeah, I get your point as far as, again, I think what I said earlier was, I get the feeling this is going in a direction of being more permissive and checking off the things that they're doing. I'd be interested in what they're doing, what is customary. I think that would help us. I don't know if it helps you, but it helps us understand what is normal with their operations at this point.
It would also help us understand what's already happening without a problem.
It sounds like
we get complaints, and then we have to react from complaints. If we're not getting a complaint and all of these things are already happening, that gives us a better feeling of what impacts those have. Again, going back to the impacts. If the neighbors aren't impacted, if it's not causing increased traffic, if it's not an issue, maybe these aren't an issue, but we don't really know what they're doing. And based on the code, we sort of, when complaints come in, we find out, oh, all these other things are happening and no special exception was ever applied for. And then staff has to figure out how to handle it. If that's what the code says is supposed to occur, what exactly do we do? And are those special exception uses?
I honestly don't know that we have, our complaints are probably more site-specific issues than necessarily the customary uses. I think it's safe to generalize it that way. So I think this will solve some of their concerns, but not.
Okay.
So does like a camp or a, Friday night ministry, it's got to be under 100, or is that just for a school?
This specifically lists the difference in a school between under 100 and over 100.
Okay.
Is an
It's
example.
not Saturday catechism class or?
No, I think it's an actual, you're providing a school.
Okay.
So I'm for wrapping this into some new categories and let's define this down. What are your thoughts on that?
One, I think Rexanne is correct, that we need to look at this.
Okay.
Only, if nothing more, to appease the minds of the ministers to make sure that they are comfortable with what we're doing and how we're doing things. But also I look at things in here as far as, is it a religious affiliated?
Into the microphone, please.
Is it a religious affiliated event? And one of my questions really to Rexanne is, in any of your discussions, did you have discussions about non-religious affiliated events that churches are taking place?
I don't know that we can differentiate between those.
Well,
That would be
I know one of the things
overstepping.
that I went through in a past life as a scoutmaster to a Boy Scout troop that was sponsored by a church. We had some parishioners that was against that and basically wanted to get us thrown out. Well, that was a non-religious sponsored event.
Actually, I think the case law
And
is
we had a
that
problem with it.
churches are allowed to do mission work. And most of the churches that I've been familiar with consider offering space to a Cub Scout group to be part of their mission to the community, to allow youth to have a place to meet and do good activities together. So they consider it to be part of their mission.
And that goes, I mean, again, these have evolved to cultural facilities, and I think that's
Where we ran
what
into
we're
trouble
going.
was the fact that being Protestant, Jewish, Catholic, Christian, the faith-based requirements for Boy Scouts required them to seek advice from various different councils or various different religions, whatever religion their child was. But as a Boy Scout group, we were allowed to have various different religions within our troop. So we had to be very careful as far as how the religions was really being portrayed because of the group of boys that we had. And that's where some of the parishioners in the church got a little bit upset over it because, well, you're allowing a rabbi to come in here and we don't want a rabbi in our church. Well, wait a minute now.
But
I think
that doesn't implicate local
You're getting
government.
into internal governance of the
better-
church
yeah.
at that point.
That you're talking about the interaction between the parents of the children, Boy Scouts of America, and the religious institutions. That does not implicate or involve local government at all.
Question though is, should we wrap this up into another category and have town staff, everybody work on defining this down into something very specific for religious organizations?
I think we should.
Okay. Scott?
I think we should combine the church and the facilities. My only trepidation about listing what they do now is if we listed what they did back in the 70s, it'd be totally different today. So if I'm kind of can't decide on that part. I mean, I'd like to see a list of what they do, but if we hold them just to that.
Well, and if
in
they
10 years
expand beyond what they are doing now, and it's something that, and they can expand and still stay within the definition at times, but there may be some times when they want to expand, like the farmer's market expanded beyond. So then they did have to come and get a special events permit, because that got to be a weekly event intruding into the community, et
I
cetera.
mean, are you going to drill it down so far as, we do marriage counseling, we do drug counseling, we do I mean, you're going to drill it down that
That's
far?
what I-
What's,
Well,
I
I
don't
think-
think we can we?
I think
Th-
we're
those
going
are-
to have to sit down with the planning people and
Yes.
see
Yeah.
what things it is that they do need to
We
let them
want to
know
sit
about.
down because those other uses are sometimes spelled out specifically in the land development code.
Once this
as a
comes
list of
together, it's coming in
uses.
front of us.
So it's not just about, I mean, there's several uses I can think of in the code, and we just use the example, the Boy Scout example of outside organizations using your facilities, almost becoming like, again, a cultural facility, other people running it, whatever it is. Those aren't included in here. That's a specific use that's listed in the land development code. I think there's other things that could be added to this, not just sliding things back and forth between this. So us getting an understanding of what they want to do and what falls under their mission, I think we can clarify and more generalize, as Sarah and I are talking about, broaden the definition, and then really hone in and I think isolate out the things that may be an issue from an impact standpoint that aren't part of the core mission, and then decide whether those fit in or not. I think 80% of it's going to be pretty easy to talk about.
When this is done, it comes back in front of us where we can hash all this out again. Okay. but
Right, the
direction-
question today is just, should we move
Should
forward?
we?
Absolutely.
And I think I've gotten the feeling from and speak up if I'm wrong,
Jim?
that you all agree that we should work further on this.
Jim?
Do agree, and I just think we should proceed with caution, but I absolutely agree. And I think, yeah, you're obviously proceeding with caution, so that's good, yeah.
Yeah, I agree as well.
Agreed.
Okay, so direction is, go put something together.
Work together.
How you guys do it, it's up to you, then bring it to us, and we'll from then look at honing it and tweaking it and such of that sort.
I appreciate that.
Thank you.
Thank you.
Conversation, absolutely. That'll give us a good head start.
All right, for the sake of, we haven't had a historic preservation meeting, and I would like to move this to next month and have a more in-depth discussion on how we're going to fix this problem. Can we skip or remove the Historic Preservation Board
Yes, you don't have to.
for today?
Yep.
And then I would like to see that on next month, of how we're going to fix that particular piece. I think we're at a point then.
Yes, and just as not to get into that, but as your role of being that board, Michelle and I were talking about this, in the empowering ordinance, I guess, that creates you in the Historic Preservation Board, there is a requirement that a member of the LPA is on that board. So right now you don't have that. Whether that means that needs to be modified or whether that means you can even meet as the Historic Board can meet. I don't know, John may know more about that, but it is a requirement that somebody from LPA sits on that, which right now you don't have. Now, whether that's gets changed to a liaison or an advisor or whatever it is, maybe that's more appropriate. I don't know. That's up to
I
you
think we
guys.
need to have a bigger discussion on that
But
and
I
have
will
that on
add
next
that.
month's agenda.
I'll add that enabling ordinance for both to your agenda for next month.
So, do I need a motion to have to pull that off, or is it okay? We're skipping it.
You're just not going to open or close, right?
I'm sorry. It would be a motion to defer the item to the next meeting.
So moved.
Seconded.
All in favor, say aye. Aye. Okay, moving along to LPA member items and reports. Jim?
In the interest of brevity, nothing.
Nothing as well.
Congratulations on you both meeting your terms to run, and good luck for both of you. I just wanted to say that. That's it.
Jim?
Thanks for all the help at sand sculpting. There's some great holiday events coming up in the next couple weeks. Check your newspaper.
One thing I want to bring into attention is on January 15th, we're putting together something at Bayfront Bistro about what is marine safe sunscreen. And I hope anyone can attend, maybe listening still. It's a long, long meeting, but that's all I have at this moment. Back to the agenda, attorney items.
Nothing.
Jason, anything?
We will be moving forward in the next, I guess by the end of the month or so, with acquiring consulting services to help with a overview of the comp plan and land development code. As we're doing these, I guess we turn them glitch and some other components, we'll bring in additional outside services to help kind of primarily reorganize and give an overview top to bottom of what some other communities are doing. And that'll, I think, help frame some of the bigger picture items. We're hitting on some of the specifics that are an issue from development standards, but it'll help reorganize some of that. We're going to be moving forward with that. So hopefully between January-ish, and June, July, August, that'll be available to us and to you. That's one thing. What else was I thinking of? Jane, I want to thank you for your comment that you sent me a couple weeks ago for that conversation. I just, as a general statement to everybody, I hope that you do believe that we're here to work with you, and we're try to make ourselves available whenever. And that goes for all the staff, and they are working hard. I think some of my response is partly because I see what they put up with up front, but I am here for each and every one of you if you need anything, and I know Sarah is too. I'm not getting, yeah, it's all Christmas spirity, I guess. But anyways.
We love you guys.
I hope so. So with that said, we're here to help you with the land development code and the items that are under your charge. So that's what we're trying to stick to. So we'd rather not get involved in some of the other issues that may come up.
Thank you, Jason and Sarah and your team for your work.
Thanks.
I do want to go back and say happy holidays to everyone
Happy holidays.
So,
before we all leave.
next meeting.
Items for next month's agenda. I would like to work on the HPV and get this thing rolling again.
Yeah, you will also have Leaky Tiki, I believe, planned right now. We'll see how that goes forward, but that'll come back before you if you remember that from summer.
I think we also had something else that was date certain from last meeting. The condos, the two condo,
200 Pearl,
yes.
Leaky Tiki planned, and then the enabling ordinance. Yes, those are what we have, and I think we have a couple, we may have a couple more text amendments for you. Hopefully they won't be as discussion heavy. Hopefully it'll be a little simpler for you.
Madam Chair and Jason, could I just confirm the date for next week? I think I had a note for it was on Wednesday. Is it on Wednesday or Tuesday for January?
I haven't asked you to change it.
I don't know if it changed
So
either.
second Tuesday would be the 14th. Unless there is conflict, but we have not asked to change it.
Okay, any public comment? No public comment? Do I have a motion to adjourn?
So moved.
Second?
Second.
All in favor, say aye.
Aye.
Aye. We are adjourned at 2:23.
That's a record long one for us.